Hey, what's up, guys? Welcome to Law-splaining the Interwebs. I'm your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. And how are you guys doing today? I was really trying to not be late. I was. But Lady Rackets made me help her build a shelf thing. I was like, I have to shower. And so I tried to shower fast, but you know, that's how it goes. What is going on here? Get closer. Get closer. All right. So oh my goodness. So we will be, today we're going to go on a journey. This journey is an instructive one. Journey's an instructive one that I want you guys to take with me because I have been suffering with it for most of the day. Doing prep and research for the show. And so I have been suffering through the Senate confirmation hearings for Amy Coney Barrett, the Supreme Court nominee. And what I realized is that all of the people asking questions have a couple things going for them. They are simultaneously senators, which means that they, in large part, run the country. Okay? That's important to remember. These people run the country. They pass legislation that determines your lives. I couldn't decide on life or lives. Like, am I speaking to you or am I speaking to y'all? That's a speechifying technique, and I haven't decided which one to use. But these people in the room with Amy Coney Barnett, ACB, they run the country, and in a lot of ways they run the world. They're some of the most powerful people on the planet. Now, combine them being senators with another reality. They're also, in this room, I believe, almost entirely lawyers. If they're not all lawyers, almost all of them are. The Senate Judiciary Committee, I was looking up the members, basically all lawyers, which makes sense. If you're going to have a say on what person will be the next Supreme Court justice, you probably want to be trained enough to read the law, right? Like, I guess you should kind of know that. You should have a background in it, is the thinking, I would assume, to these appointments. Or to the appointment of senators to the Senate Judiciary Committee. Now, do I keep saying Barnett? Barrett. I mean Barrett. You know who I'm talking about. I'm going to just say ACB from now on, because I keep mixing up her name. I'm like Amy Coney Barrett, Amy Coney Barnett, whatever. We all know there's one proper way to address her, and we'll get to that in a little bit. But here's the thing. They're all lawyers. They're all senators. And the vast majority of them are, pardon the expression, functionally retarded. I mean, I don't understand how they get through a day. I genuinely don't. And when we start watching these videos, you're going to see, if you haven't watched it, you're going to see and just how dumb these people are. Like, they're just dumb. I don't know how else to express it. These are not smart people. Their questions aren't good. The only thing they're kind of good at is politicking, And they do a lot of that. They waste a ton of time politicking. In fact, one of the speeches, it was speech. I have to classify it as a speech because there were no questions. It was just a guy who sat and talked for 30 minutes at ACB. Didn't ask her a single question. Said he was gonna, didn't do it. Then he's like, well, I guess we'll have a good discussion tomorrow. It's like, haha, I doubt it, because I just heard you talk at her for 30 minutes today, and that wasn't particularly enlightening. And if that's the basis for your discussion tomorrow, it's going to be full of stupidity. These people are stupid. Now, some of the people in the room aren't, but everyone I watched today was pointless. Pointless person. Now, this is going to sound partisan, it's going to sound biased, and it's honestly not. Okay? This part won't. I don't care if Amy Barnett, whatever her name is, Amy Barrett, I don't care if she's the next judge. I don't care. I have zero interest in her jurisprudence. I have not researched her record. I don't give a darn whether she is the next person. It doesn't matter to me. It could be anybody. All right? I don't care. I'm not going to presume to know how a judge will rule all the time. Like everybody seems to think they'll know, and then they're always surprised when these judges rule differently. Well, guess what? You didn't know. Okay? Shocker. So I don't bother trying to know. What I got is a person in front of me, and she's in the room with a whole bunch of other people who are asking her questions. Now, the second part of this, factoring into my comments so far, is I did not watch a single Republican ask her questions. And I'll tell you why. There isn't really a reason to. Because the Republicans have already basically indicated that she will be the next judge. They're going to vote for her. They're not really interested in asking questions to change their own minds about it. Neither are the Democrats. We'll get there in a minute. They're just not interested in that. And therefore, I have a limited amount of time during the day. I spent about 3 hours watching these things. And I had to focus where there would be show-worthy material. And I don't think the Republicans were going to produce it, which is fine. That's not their job here. They're not show content prep for my show, right? Okay. I did see the big moment that, Crowner put a thug life on her or whatever. And while it was amusing, and the reality of it was fun, the meme of John Cornyn asking her, what materials she's reading from. What materials are you reading from? He already knows she doesn't have any in front of him or in front of her. And that was the contrived nature of the question. He was pointing out to his Democrat colleagues that this chick was qualified. And it's weird because some of the reactions were oh, she just owned that guy. It's no, she didn't really own him. He knew that was the charade. That was it. So it was a good moment for her, and it plays well in clips and stuff like that. But once you realize that question was asked by a Republican, the whole purpose was to show that she is sharp and she is smart. But that's not really the point of these hearings either. So I liked the moment, but that's the type of stuff that I didn't think would be very useful to look at this. Now, that said, let me be clear. Of all the interactions I watched today, she was the smartest person in every single one of them. By a ridiculous margin. By a ridiculous margin. And it highlights some very important things about Supreme Court justices. Whether you like them or not, largely, they are very, very qualified for their job. They're very, very good at their job. You can disagree with their judicial assessments. You can disagree with their judicial tracks and the interpretations that they come up with. You can disagree with their rulings. They're not dumb people. senators are often dumb. Supreme Court justices really aren't. And she showed that today. She is very, very clear, precise, thoughtful, smart. She's fast with her responses. They're consistent and they're well done. She's sharp. So that was nice to see. But it was a hard contrast to everybody asking her questions. Now, who I watched today, I watched Dick Durbin. Depressing. I watched the Hawaiian chick. Depressing. I watched Dick Blumenthal. Very depressing. Very, very depressing. That guy's a corpse. Who else? Let me see. Let me see what I got here. I watched Sheldon Whitehouse. That's the guy we're probably not going to watch today because he just speechified. He didn't do anything. Maisie Hirono is the Hawaiian chick. That's who I was talking about. And I watched Amy Klobuchar. Oh my God. That was atrocious. That was an absolutely atrocious interview. All right. So we're going to probably watch, we'll start with, I think, Dick Durbin. And then we'll watch Amy Klobuchar, because I think those two play well together. Then we'll watch, I started watching Kamala Harris, and I didn't have time to get through it. So I think we'll watch, let's do this. We'll watch Dick Durbin. We'll watch Amy Klobuchar. Then we'll watch Kamala Harris, because I haven't seen that one. And I think that'll be fun, because we'll get like a live reaction. There's some things in Durbin and Klobuchar's that I want to go through. And then if we have time, we'll come back to Richard Blumenthal, and then we'll go into Maisie Hirono. All right? But Maisie Hirono was an embarrassment today. She was disoriented. She was discombobulated. I want you to compare Maisie Hirono to people you watch for entertainment. Like, you know, on television. Like, not me. I don't mean to do it that way. But anyone whose live content you watch anywhere. I don't know if you guys watch like Ethan Van Sciver or just really anybody. Really anybody. And compare the ability of the people you watch just for entertainment, who are often not qualified in the way that these senators are, right? Maisie Hirono went to Georgetown Law. Amy Klobuchar went to Yale, not for law school, but she went to Yale for her undergrad, and then she went to law school somewhere else. Like, these people have pretty impressive pedigrees. And pay attention to their inability to construct thoughtful sentences, to convey ideas very well, to finish out sentences that they start. Like, just ask them to complete a thought. And then notice that they have all of this written down in front of them. And that's terrifying to realize. Not only are they bad at this, they are prepped heavily for it, and they're still bad. They're still bad. So, yeah, we'll do this. I want you to keep these things in mind. I didn't watch Cory Booker's. Someone mentioned Cory Booker. What did they say? What did they say here? What about Cory Booker? The fake tears and trembling lip had me on the floor. No! Did he cry? Was he, yarr, yarr. What is happening? Was he crying? Dick Blumenthal almost started crying. I'm in the car driving, and I hear him going. I'm like, are you crying? Are you crying? You're crying on TV? What is wrong with you? So anyway, let me not give the Republicans a pass here. On the Senate Judiciary Committee, there's approximately one Republican I like and think has the qualifications to do the job he's doing on the Senate Judiciary Committee. And that's Ted Cruz. No matter what you think about Ted Cruz's politics or anything else, ignore every other role that he has as a senator, okay? On the Senate Judiciary Committee, as a person who is qualified to ask questions and assess the value of a Supreme Court justice, I think Ted Cruz is uniquely qualified to do this, to do that. He's a very, very good high-level constitutional lawyer. He's shown it throughout his career, and he has the respect of people who don't even like him in his ability to do that. So, in that vein, he's one of the only people in that room that I think might be smart enough to do it. Lindsey Graham, I don't care. I don't think he's particularly smart or great. I don't care about John Cornyn. None of these people impress me. So I'm not like giving Republicans a pass here. I just didn't expose myself to their particular bent of idiocy today. That's why I was saying earlier, tying it back in. I know this is going to sound biased. It's really not. I don't give the Republicans a pass on this stuff. And I literally can't express enough that I didn't watch their questioning because on balance, I didn't think it would be informative in just about any way. So I disregard their opinion. It's not important to me. I don't think their questions are going to be challenging or interesting. I think they'll be milquetoast. So, is Mike Lee on the Senate Judiciary Committee? He might be okay. He seems like a pretty sharp guy, but I haven't spent a lot of time listening to him. I try to avoid politicians and politics, but I know that this type of stuff is on people's minds right now, and I think it's good content for the show to show some really good and really bad high-level legal discussion going on for one of the most important things that's going to happen this year, and that is the appointment of a new Supreme Court justice. All right? So that's my thinking in all this. That's what we're going to do today. Let me queue up Big Dick Durbin as the first one we're going to watch. Now, each of these segments is about 30 minutes. I'm going to try really hard not to pause too often. So I might actually talk over them more like it was live because I want to keep them moving. But if something really, really sticks out to me, I'll probably pause it. So don't hold me to saying I'm not going to pause it because I probably will, but I'm going to try and keep it at a minimum. All right? That's the goal. Let me make sure I've got this framed up right. Oh my goodness, guys, I'm so excited. I get the first of my new couches on Thursday. Haven't had couches. All our couches are gone. They're destroyed. So, it's just like not having a couch. Except for the one. The one couch is there, but haven't had other couches. This is great. We are going to do Super Chats first. Yep, I'm just getting this queued up. All right. Okay, so here we go. We'll start with the Super Chats first. Felipe Mouve, thank you for masking me as a pirate. Very, very happy to be a pirate. Bad Vibe says, hey, Nick, a term was mentioned in regards to independents and judges. I don't know the term ACB used, but I am curious about the definition. Not sure what term it was. Do you know who she was talking to when she said it? I couldn't tell you. WZRBS says, disagree on intelligence of justices. Pretty sure Kagan has an IQ of 12 and is also a diddler like RBG. Look, if you can get away with eating children alive, you're pretty intelligent. And that's why I say they're kind of smart. Andrew War Snowboard says, Frey, Omar, Walls, Klobuchar, Tina Smith, Ellison, Angie Craig, Colin Peterson, Beeman, etc. Is there one prominent Republican in this state? No, there was back in 2010, and then his district got redistricted in 2012, and he disappeared. I forget his name. He was down from the Mankato area. Crook. I don't remember. He like rose to prominence real quick, and then poof, gone. One of my buddies worked for his campaign. Big T Armada says there's no crying in Senate hearings. It's Kaki Onsai. Not Norm Coleman. Oh, geez. Skagi Onsai says, as Kermit, Mr. Blumenthal, are you crying? Are you crying? Seriously? Are you crying? There's no crying in the Senate chambers. There's no crying in baseball. Thank you for doing this so I don't have to. You're welcome, I guess. Puggernaut says, should the Zodiac Killer really be picking our Supreme Court justices, Nick? Yeah, he's got a long history of effective selection. Think about that. Ted Cruz, the Zodiac Killer, selected his victims so carefully that they still only know that it's Ted Cruz today. But up until he popped up in politics, they had no idea. They had no idea. The man is an effective selector. 200 Watt Studio says, Cory Booker, no kids, asks ACB, 7 kids, 2 black, are you opposed to white supremacy? He demanded that she directly say she was opposed to white supremacy. When she did, he went on a long speech about Trump never saying it. What a waste of space. What a waste of space. Oh. Okay. I believe we've got the volume set. We've got all this. Let's transition. Okay. Here we go. Are you guys ready for this? This is Senator Dick Durbin.
Judge Barrett and your family for being here with us today for this marathon of questioning.
Thank you, Senator Durbin.
Appreciate it. I would like to respond to two of my colleagues quickly before I ask a few questions of you.
Why?
Who came up with this notion, this insulting notion that you might violate your oath?
You did.
Where could this idea
Your
have
party.
come from?
Your party
Could
did
it have
it.
come from the White House?
No,
Could it
you
have come
did
from
it.
the president's tweets of what he expects a Supreme Court nominee?
It is very quiet. Let me see and make sure I've got the settings real quick that we've got all these maxed out. God, it's maxed out. That is the maximum volume. I'll turn myself down. I can't actually turn the video up. So I'll turn myself down just a little bit. All right. This is me at my loudest. Here's my normal talking voice. This should be comparable to the video now, I hope. I hope. So here we go.
Need to do politically for him. That's where it comes from. That's where it originated. And you have said very clearly today, without equivocation, you are not going to be influenced by President Trump's importuning or the importuning of this committee or anyone else, which is what we expect you to say. But this notion that this whole idea of your being used for political purposes is a Democratic creation. Read the tweets, and you have plenty to work with. Read the tweets.
Read the tweets.
The second thing I would like to say is I'm not going to spend a lot of time defending the Affordable Care Act, although I think it's the most important single vote I've cast as a member of Congress.
This guy's
period.
cheeks are retreating from his brain.
That when the chairman opened up on it and said what he did, I was puzzled. 3 states get 35% of the money? How can that possibly be true? Well, it turns out because those states decided to extend Medicaid coverage to the people who lived in the states, and his did not. And as a consequence, fewer people in South Carolina have the protection of health insurance, And those that do are paying for their services, and those that don't are not, which imperils hospitals and others in the process. So I would say there is an explanation as to why some states are spending more. And incidentally, there was a Republican governor of your state, Indiana, by the name of Mike Pence, who decided to break with other Republican governors and extend Medicaid coverage under the Affordable Care Act. I think it was the right thing to do for Indiana as it was for Illinois. But that's part of the reasoning. Let me just say that the Affordable Care Act really is at the heart of this, as you can tell on the Democratic side. We really believe the Supreme Court's consideration of that case could literally change America for millions of people. I have with me.
That's only because you did change America for millions of people.
At least be aware of, because they're pretty amazing people. But
I hate this part.
This is the Williams family. They live in Naperville, not too far.
Let me tell you about this
Chicago.
one person in the
Kathy
middle
and
of
Les
somewhere.
Williams have 4 sons from left to right: Matt, Joey, Tommy, and Mikey. Matt, who's 27, was diagnosed with type 1 diabetes when he was 13.
Diabetes.
The other 3 Williams boys were all born with cystic fibrosis. Joey is 24, Mikey's 21. Sadly, Mikey's twin, Tommy, after this picture was taken, passed away in January 2019 from complications. This is the last photo that was ever taken of their full family. Here's what they wrote me. We cannot imagine having to go through losing another child. People with cystic fibrosis require daily medication, regular doctor visits, access to high-quality specialized care.
Durbin actually does get to the question
like cystic fibrosis
better than some other people.
Cannot be discriminated
He just
against.
has this long
The
preamble.
ACA's protections ensure a ban on annual and lifetime caps and enforce the requirement that insurers cover essential health benefits such as hospitalizations or mental health
Who's the
services.
whale in the picture on the
People
far
with
left
CF
there?
and other pre-existing conditions need adequate, affordable health care to live longer, healthier lives. That's why we keep bringing this up. Real people that we run into all the time. There's a chart here I might show too.
I'm sure the judge doesn't know
On the
anything
Republican
about
side, there's
real
some
people being involved in these
obvious
issues.
controversy as to whether we're right or wrong. But there are an awful lot of people in each of the states represented by our Republican senators who have their health care and literally, in some cases, their lives hanging in the balance. South Carolina, 242,000 people would lose their insurance coverage if the Affordable Care Act were eliminated. 2 million living in that state have pre-existing conditions. You can
I have
imagine
pre-existing
the list goes on.
conditions.
Thank you.
I
Here's
still
what it
think the
comes
law
down
is
to.
shit.
You've been unequivocal in being critical of the decisions both in NFIB Sibelius and in King Burwell. And we naturally draw the conclusion.
Let me really quickly let you guys know, NFIB versus Sibelius was the first major Obamacare decision. It's the famous Obamacare decision. Roberts' famous Obamacare decision where he upheld the individual mandate. He struck down the state mandate. That is the big one, NFIB versus Sibelius. So the other one I'm not really familiar with. What you're going to hear now, you're going to hear some people misconstrue the words of Roberts as being from Barrett. So this is going to be great.
There's going to be a third strike when it comes to Texas and California. You said it won't affect pre-existing conditions. If the petitioners have their way, there will not be an Affordable Care Act to protect pre-existing conditions on the severability question. So give us an insight how you can be so unequivocal in opposing the majority decisions in NFIB Sibelius and in King and Burwell, but have an open mind when it comes to the future of the Affordable Care Act.
Sure. Thank you for that question, Senator Durbin, because it gives me an opportunity to make my position clear. When I wrote, and this was as a law professor, about those decisions, I did critique the statutory interpretation of the majority opinions. And as I mentioned before, my description of them was consistent with the way that Chief Justice Roberts described the statutory question. But I think that your concern is that because I critiqued the statutory reasoning, that I'm hostile to the ACA, and that because I'm hostile to the ACA, that I would decide a case a particular way. And I assure you that I am not. I'm not hostile to the ACA. I'm not hostile to any statute that you pass. And the cases on which I commented, and we can talk at another time, I guess, about the context, the distinctions between academic writing and judicial decision-making, but those were on entirely different issues. So to assume that because I critiqued the interpretation of the mandate or the phrase established by a state means that on the entirely different legal question of severability, I would reach a particular result, just assumes that I'm hostile. And that's not the case. I apply the law, I follow the law, you make the policy.
So let's talk about that for a moment from a different
Yes,
issue
let's talk about it.
perspective. Bear with me for a couple questions. Have you seen the George Floyd video?
What does that have to do?
What impact did it have on you?
Senator, as you might imagine, given that I have 2 Black children, that was very, very personal for my family. Jesse was with the boys on a camping trip out in South Dakota, so I was there, and my 17-year-old daughter, Vivian, who's adopted from Haiti, all of this was erupting. It was very difficult for her. We wept together in my room, and then it was also difficult for my daughter, Juliet, who's 10. I had to try to explain some of this to them. I mean, my children, to this point in their lives, have had the benefit of growing up in a cocoon where they have not yet experienced hatred or violence. And for Vivian, you know, to understand that there would be a risk to her brother or the son she might have one day of that kind of brutality has been an ongoing conversation. It's a difficult one for us, like it is for Americans all over the country.
And so I'd like to ask you, as an originalist who obviously has a passion for history, I can't imagine that you could separate the two,
You can.
to reflect on the history of this country. Where are we today
you
when
can
it comes
separate
to the
the
issue
two.
of race? Some argue it's fine. Everything's fine, and you don't have to even teach children about the history of slavery or
Who
discrimination.
says that? Who
Others
argues
say
that you
there's
don't have to
implicit
teach the
bias in
history
so many
of
aspects of
racism,
American
slavery,
life
discrimination?
that we have to be very candid about and address.
Who says that?
Others go further and say, no, it's systemic racism that's built into America, and we have to be much more pointed in our addressing it. How do you feel?
So I think it is an entirely uncontroversial and obvious statement, given, as we just talked about, the George Floyd video, that racism persists in our country. As to putting my finger on the nature of the problem, you know, whether, as you say, it's just outright or systemic racism, or how to tackle the issue of making it better, those things, you know, are policy questions. They're hotly contested policy questions that have been in the news and discussed all summer. So while, you know, as I did share my personal experience, I'm very, you know, happy to discuss the reaction our family had to the George Floyd video. Giving broader statements or making, you know, broader diagnoses about the problem of racism is kind of beyond what I'm capable of doing as a judge.
Exactly.
Well,
That's not her
I would
job.
doubt that. I just don't believe you can be as passionate about originalism and the history behind language that we've had for decades, if not centuries, without having some thought about where we stand today. But I'm not going to press you on that.
It's because
I'm going to take you to a case which
has
I
thoughts
have
on
read
it.
and
It's
reread.
not her job
Cantor
as a
versus
judge
Barr.
to share
You
them.
know the case well because it's already been referred to. And it clearly is a case where you had your day in court. You wrote the sole dissent. A
I have
64-page
it
case,
pulled up right
37
now.
pages were your dissent. So you gave to the court, I assume, a pretty full accounting of your thoughts on the subject. And here's the way I understand the case.
See?
A
Cantor v. Barr.
fellow named Ricky Cantor from Mequon, Wisconsin, invented some pads to put in a shoe to be sold to particularly older Americans under Medicare to relieve foot pain. And he designed them and submitted them to Medicare and didn't get the approval that he was looking for, but instead sold them and represented to many customers that they had been approved by Medicare. And so he was charged with fraud. Now, this wasn't a matter of a casual misapplication of the law. When it was all said and done, Ricky Cantor of McQuan, Wisconsin, ended up spending over a year and a day in federal prison, paying somewhere near $300,000 in penalties and fines and $27 million in a civil settlement on this issue.
Okay.
So this was not a casual wrongdoing. This man was a swindler, and he was taking the federal government for a ride, as well as other customers.
This man's grift is legendary.
About his product, and paid a heavy price for it.
Yep.
Then he decided, having left prison, that it's just fundamentally unfair.
Durbin is a lawyer.
The law says that if you've been convicted of a felony, you can't own a firearm. Now, I don't know what his appetite is when it comes to firearms, whether it's a revolver or
he likes to eat revolvers particularly.
Clip. I have no idea. But
with a banana clip, that's the best one to have an appetite for.
It was just mail fraud, and you're taking away my Second Amendment rights. So 2 out of 3.
Real quick. I don't like pausing so much. I don't think that nonviolent felons should lose their gun rights forever. I really don't think that. In fact, I'm not entirely sure that violent felons should lose their gun rights forever. After they've served their sentence, after they've served their probation following their sentence, I'm not entirely sure that they shouldn't be able to have their gun rights restored. I don't know why we have permanent loss of certain inalienable rights because someone commit a crime at one point. A person who commits a crime at 19 is, in many, many cases, is not the same person at 45. Especially if they serve 3 to 5 years in prison for it, and then they come out and they have 10 years of probation, and now they're entering their 40s. They've a lot of times have changed their life, and if they haven't, they tend to go back to prison. So, I'm not sold on the idea here. And I don't think that a guy who just bamboozled a bunch of old people into buying lifts for their shoes deserves to have his gun rights taken away. Call me crazy. Call me crazy.
Of your colleagues then basically said, sorry, Ricky, you have forfeited your right to own a firearm because of your conviction of a felony. You took a different approach, exactly the opposite approach, and went deep into history. I think the earliest citation I see here was 1662, to figure out just what was going on here and whether or not he had to have committed a violent felony to have forfeited this right to own a firearm. Have I stated the facts close to what you...
Yeah. Am I not clear when I'm talking? Like I said, after all of their punishment is served, I'm not entirely sure. While they are in prison, while they're on probation, I think stripping their gun rights is fine. And it may be fine for all of it. But I'm not entirely sold on the idea because I haven't seen any data to support why it should happen that way. That data may be out there, but it's never been presented. It's just been presumed. And here's the interesting thing is, okay, even if you give the violent felons, you say, okay, violent felons can never have a gun again, right? What about a guy who just, as ACB points out, I don't think it's with Durbin, but it's with another person who says in some states, selling pigs without a license is a felony. Well, I mean, so you sold pigs without a license, so you can never have a gun again? I don't know about that. I'm not sold on the idea. Not at all.
You remember?
I don't remember the amount of the loss, some of those details, but yes, Ricky Cantor was convicted of selling fraudulent shoe inserts, and it was a felony.
Mm-hmm. $27 million settlement.
And remember the reason his crime was a felony is because there exists a Food and Drug Administration who decided that his shoe insert needed FDA approval, and he didn't get it because he probably didn't pay the right person. So instead, he said they were approved. They were FDA approved. It's a shoe insert. Like, you can walk into Walmart and buy a Dr. Scholl's insert without a doctor or without anybody assessing whether that insert is the right one for you. Like, you can do that because they got some approval at some point in the past. This guy didn't get it. In a libertarian society, the FDA is a ludicrous proposition, especially on a damn shoe insert. Like, I get it on a pharmaceutical. I get it on a prescription drug, sure. On Tylenol or whatever. I at least can understand the regulatory aspect of it. But this is a shoe insert.
On the way. So I'd like to take you into your thinking on this.
No guns. You
When the
put
Heller
something in someone's
decision was
shoe.
handed down, Justice Scalia expressly said, I'm not taking away the authority of government to impose limitations based on felonies, not violent felonies, felonies and mental illness. He said as much in the Heller decision. And yet, this man who was your inspiration, as you've told us all, you decided he was wrong and that it had to be a violent felony. Can you explain why?
I can. So we've talked about precedent, and in my court, the Seventh Circuit, there is precedent saying that that phrase doesn't control, as you know, my colleague Judge Frank Easterbrook has said a number of times, that judicial opinions aren't statutes and shouldn't be read as if they were. So Heller obviously wasn't about the scope of the right, you know, its application to felons or those who are mentally ill, et cetera. And so that passage was dicta. It didn't fully dive down into it. But what I did was apply Heller's methodology. Both Justice Scalia's majority opinion and Justice Stevens' dissent used an originalist methodology to answer that question. And I concluded that based on that history, one couldn't take the right away simply because one was a felon, that there had to be a showing of dangerousness. And I didn't rule out the possibility that the government might be able to make that showing about Ricky Cantor. But I think we could all agree that we ought to be careful of saying that because someone's a felon, they lose any of their individual rights.
I want to get to that point, but I'd like to stick with this for just a moment more. I'm honored to represent the city of Chicago and the state of Illinois.
Great.
It's a great city, but it has great problems.
Here we go. What are you doing to control your crime in Chicago, pal? This is an important point she made. That's why I'm pausing it. I know I said I wouldn't, but I lied. Because I'm, you know, whatever. I'm going to be in Congress someday. Scalia's point about felonies is dicta. Dicta is non-controlling language. It's non-controlling language that's in a judicial opinion. So controlling precedent from a judicial opinion comes from the narrow issues that are determined in that opinion. So when you have like research software like Westlaw or whatever, they have key sites that help out with this. Now, these are Westlaw creations. Lexis has them as well. So does Bloomberg Law, all of these things. But they basically hammer out the specific issues that the court's actually addressing. And if you have phrasing related to an issue that's not laid out by the court as an issue before the court, then the language they use on that is informative. It's dicta. It's an opinion, but not a judicial opinion. And so there's a lot of stuff out in Supreme Court decisions and lower court decisions that is said that isn't controlling language. It is not usable. If you cite to it, you typically have to indicate that this is a persuasive passage, but it's not authoritative because this wasn't the issue that was before the court. That's why it matters that that passage from Scalia in Heller is dicta. And a lot of what Scalia talks about in Heller is dicta. He's giving a summary of the historical perspective on militias and on the individual rights of gun ownerships that stuff, a lot of that is dicta. You can't say, well, in Heller, Scalia said that the militia is this, therefore, by law, that's what the militia must be. You can't do that because that's not what the issue was in Heller. So this is a very roundabout way to get to this. What she was saying was, and is very important, is that the government can restrict gun rights. What they have to do is have a showing that the person is a dangerous felon, that they have a propensity for danger. And they didn't do that with Cantor, and they don't do that at all in their assessment of who loses their gun rights. Now, in a lot of cases, we actually do, and they get to this, but we do have distinctions on felonies versus violent felonies. Like we do this already in other areas of law and in other statutes. This can be done. Durbin is going to make a really stupid point about it, and she's going to point out what I just said. And in fairness, it's because I stole it from her, but she's right. Let's keep going.
Problems too, and one of them is gun violence. On the average, we know in America, 100 Americans are killed every day by gunfire, 40,000 per year. In the city of Chicago, more than 3,200.
40,000 Americans are killed by gunfire per year because approximately 32 to 33,000 of those are suicides. 32 to 33,000 of those are suicides, and including them in gun violence statistics is disingenuous, it's stupid, it's bullshit, and they need to stop, because you're not going to prevent suicides by preventing violent felons from owning a gun. There are about 7,000 to 9,000 firearm-related killings that are not suicides, that are homicides per year. Some of those are accidental. Many of those are just murder. Okay? But this is, of course, how they do this. And another person is going to misstate that statistic later.
100 people have been shot just this year, 3,200. According to the city's gun trace report in 2017, the majority of illegally used or possessed firearms recovered in Chicago are traced back to states with less regulation over firearms, such as Indiana and Mississippi.
Indiana is where ACB is from.
2017 report found that Indiana alone was the source of 21% of all Chicago's recovered crime guns. We know how it works. Where you live, you know how it works. There's a traffic between Chicago.
You want to lower that
Indiana,
percentage, just
Michigan,
legalize gun
constantly.
purchases in Chicago, and they won't go to Indiana.
In Gary, Indiana, and other places. And when they're selling these firearms without background checks, unfortunately, these gangbangers and thugs fill up the trunks of their cars.
Whoa! Gangbangers and thugs! Dick Durbin with the dog whistle, the racist language. Put the hood on, Mr. Durbin. The Grand Dragon is waiting.
Firearms and head into the city of Chicago and kill everyone from infants to older people. It's a horrific situation. Law enforcement is fighting it.
The overwhelming majority, if I'm not mistaken, and someone, if you want to look up this statistic and correct me, go ahead. But I believe the overwhelming majority of murders in Chicago, murder victims in Chicago, are black men between the ages of 15 and 30. I think they make up the largest percentage of those killed. And I think that you're not going to find that infants and the elderly are super high up on that list.
Trying to get Indiana to at least do background checks at these gun shows with limited success. And we are trying to apply the standards that you disqualify yourself from buying a firearm to felonies and mental illness. And you want to take away part of that protection with your decision in this case.
Goddamn, Dick, stop it. Stop making me pause this damn video. She doesn't want to take it away. And she can't. It's a dissent. The dissenting opinion can't actually do that. So no, she's not trying to take it away with her opinion. She's laying out why she disagrees with the conclusions that the majority reached. And one of the reasons is that based on a historical textual analysis of case law going all the way back to the 1600s, we find that restricting the right to arms has only happened traditionally to violent or dangerous felons, where there's a showing of danger, and that the blanket application to felons is new and inconsistent with historical doctrines. That's all she said. In fact, and as an originalist, she's going to look back at that historical perspective and say, well, if it was that way then, it should be that way now, unless we have some particular reason to change it. Ugh.
Because if you eliminate felonies and just confine it to violent felonies, you're opening up more opportunities for people to buy firearms, are you not?
Well, Senator, you referred to gang members and thugs buying guns in Indiana and taking them across the border. And certainly that, if they had felony convictions for doing the kinds of things that members of gangs and thugs do, nothing in Cantor says that the government can't deprive them of firearms. And nothing says, in my opinion, that the government can't deprive Ricky Cantor of having firearms. They simply had to make a showing of dangerousness before they did so. And nothing in the opinion opines at all on the legality of background checks and gun licensing. Those are all separate issues.
But the majority zeroes in and says what you've just said is totally impractical.
It's not.
You're going to go case by case and decide, well, what kind of felonies and what kind of person. And then they go on to produce evidence. I could read them.
They do it all the time. They do it all the time. We have all sorts of classifications. We have class A, B, C felonies in different states. We have violent felonies. We have drug felonies. We have moving violation felonies. We have, we already have violent felonies. We have domestic felonies. We have felonies that are related to gaming. We have felonies related to piracy. We have all sorts of shit. They already have thousands of classifications across this country. It's a nonsense approach that how are we going to classify these? Oh, I don't know. Write a statute.
The numbers here, but you know them well because you wrote the dissent, where the likelihood of committing a violent felony after being convicted of a felony is pretty dramatic. And they're saying to us, don't force us to make it case by case. We want to make it by category. It's the only practical way to deal with the thousands,
make it by
if not
category.
millions,
Violent
of people
felonies
who are buying firearms.
Dangerous felonies.
You are aware of the fact that even those who are so-called not violent felons, quote, only felons, like Ricky Cantor, have a propensity to commit violent felonies in the future, are you not?
There was no evidence of that in the case. And we, on courts, for example, the Armed Career Criminal Act, that's a federal statute, have to make judgments categorically all the time about what count as crimes of violence. So I don't think that's beyond the ken of courts in any area to identify which felonies are violent and which felonies are not.
So let's go. Excuse me, but I want to address that issue.
Did you see
Let's
that
go to
look
page
on her
21
face?
Of the opinion, and what the court said, the majority in the court. Most felons, they quoted Yancey, most felons are nonviolent, but someone with felony conviction on his record is more likely than a non-felon to engage in illegal and violent gun use. For example, one study, this goes on to say, 210,886 nonviolent offenders found that 1 out of 5 were rearrested for a violent crime within 3 years. So the evidence is there. It is there for the court to consider, and you ignored it.
Senator, I didn't ignore it. As I recall, that evidence and the studies were unclear. And let's see. I can't remember as I'm sitting here the details of all the statistics. But
here's part of the problem. The majority opinion will cite one set of statistics, but there may have been 2, 3, 4, 5 different statistics, different studies, different sources. And when the majority is writing their opinion, they will write what was the most persuasive set of statistics for the majority. It doesn't mean it's the only one presented, and it also doesn't mean it was clear. I don't know about this particular case. I'm just talking in general about how these things play out.
But I did consider it, and I recall saying something in the opinion about the reliability of those studies, because they didn't say whether someone had been convicted of a nonviolent crime but had later been convicted of a violent crime as well. I mean, felonies cover a broad range of things, including selling pigs without a license in some states, redeeming too many bottle caps in Michigan. I mean, so felonies now
redeeming
cover
too many
a broad
bottle caps.
swath of conduct, not all of which seems indicative of whether someone's likely to abuse a firearm.
So let me take you, I'm not going to go so far back in history, but I'm going to take you back in history for a moment and note that when that Second Amendment was written and you did the analysis of it, we were talking about the likelihood that a person could purchase a muzzle-loading musket. We are now talking about virtual military weapons that can kill hundreds of innocent people. It is a much different circumstance. Maybe an originalist pins all their thinking to that musket, but I've got to bring it to the 21st century. And the 21st century has people being killed on the streets of Chicago.
This is a stupid line of questioning.
Because of the proliferation of deadly firearms. But let me bring it closer to home and tie up the George Floyd question with where I'm headed.
What does
There's
George
also
Floyd
a
have to
question
do
as
with this?
whether the commission of a felony disqualifies you from voting in America. And the history on that is pretty clear. In an article, the American Journal of Sociology found that many felony voting bans were passed in the late 1860s and 1870s when implementation of the 15th Amendment and its extension of voting rights to African Americans were ardently contested. It still goes on today with voter suppression. But we know that in Reconstruction, in the Jim Crow era, in Black Code era, that was used. A felony conviction was used to disqualify African Americans from voting in the South and many other places. The Sentencing Project today has found that more than 6 million Americans can't vote because of a felony conviction, and 1 out of every 13 Black Americans have lost their voting rights. The reason I raised that is that in your dissent, you said disqualifying a person from voting because of a because of a felony is okay. But when it comes to the possession of firearms, wait a minute, we're talking about the individual right of a Second Amendment. What we're talking about in voting is a civic right, a community right, however you define it. I don't get it. So you're saying that a felony should not disqualify Ricky from buying an AK-47, but using a felony conviction someone's passed to deny them the right to vote is all right?
Senator, what I said was that the Constitution contemplates that states have the freedom to deprive felons of the right to vote. It's expressed in the constitutional text, but I expressed no view on whether that was a good idea, whether states should do that. And I didn't explore in that opinion because it was completely irrelevant to it what limits, if any, there might be on a state's ability to curtail felon voting rights.
Did you not distinguish the Second Amendment right from the right to vote, calling one an individual?
No, Durbin, no. Okay, I gotta step in for just a second. She doesn't do that. She talks about the existing distinction between the two of past courts. No, Durbin. But they are different, but no. She's talking about the past. Fucking
Right under the Constitution, and the other a civic right?
That's consistent with the language in the historical context, the way the briefs described it, and it was part of the dispute in Heller of whether...
Really important, and I don't mean to... I'm going to let her talk. I'm going to mansplain for just a second. No, I'm just kidding. The briefs describe it this way, and this is important because appellate judges take from the briefs submitted by the parties with frequency when they're formulating their opinion, especially if the dissent is trying to articulate the argument and both sides mention it this way, they're definitely going to use the language that both parties used in their brief, as long as that language is consistent with the actual law that exists. So when the parties are citing the distinction between an individual right and a civic right, and they're citing to existing case law, when the judge goes in and researches that case and looks at it, of course they're going to use similar or even the very same language that the parties used in their briefs. Why? Because if it's a winning argument in a brief, it's probably a good one.
The Second Amendment was an individual right or a civic one that was possessed collectively for the sake of the common good, and everybody was treating voting as one of the civic rights.
Well, I will just tell you that the conclusion of this is hard to swallow. The notion that Mr. Cantor, after all...
Things are hard to swallow because of your baseball-sized lymph glands and those fucking jowls on your face.
That he did should not be even slowed down when he's on his way to buy a firearm.
Why
My
should
goodness,
he?
it's just a felony. It's not a violent felony that he committed. And then to turn around on the other hand and say, well, but when it comes to taking away a person's right to vote, that's the civic duty. It's something that we could countenance. That really goes back to the original.
It's not what she
George
says in
Floyd
the opinion
question.
at all.
That was thinking in the 19th century that resulted in voter suppression and taking away the right to vote from millions of African Americans across this country. And it still continues to this day. I just don't see it. I think the right to vote should be given at least as much respect as any Second Amendment right. Do you?
Write a law! Write a law for it, Durbin! Write a law! Just make a law saying voting rights don't go away. Pass it. That's your job.
Senator, the Supreme Court has repeatedly said that voting is a fundamental right, and I fear that you might be taking my statement in Cantor out of context. What I said in that opinion was distinguishing between, it was a descriptive statement of the state of the court's case law, comparing it to stripping felons of Second Amendment rights. I expressed no view about what the constitutional limits of that might be or whether the law should change with respect to felon voting rights. And obviously that's a contested issue in some states that are considering it right now. And I have no view on that, and it wasn't the subject of Cantor.
It may not have been, it wasn't the subject of the case, that's for sure. But in your writings, you raised this. It was part of your dissent, discussing the right to vote and felony conviction, eliminating it. I'm afraid it's inescapable. You've got to be prepared to answer this kind of question.
She did answer this kind of question. You just don't understand the answer because you're stupid. Here, we'll do this real quick. Vote. Voting is mentioned a couple times in this opinion. So here we go. Nor have the parties introduced any evidence that founding-era legislatures imposed virtue-based restrictions on the right. Such restrictions applied to civic rights like voting and jury service, not to individual rights like the right to possess a gun. In 1791, and for well more than a century afterward, legislatures disqualified categories of people from the right to bear arms only when they judged that doing so was necessary to protect the public safety. That's just what she's saying about what the parties introduced. The next one. That is an unusual way of thinking about rights. In other contexts that involve the loss of a right, the deprivation occurs because of state action, and state action determines the scope of the loss, subject, of course, to any applicable constitutional constraints. Felon voting rights are a good example. A state can disenfranchise felons, but if it refrains from doing so, their voting rights remain constitutionally protected. So too with the right to keep and bear arms. A state can disarm certain people, for example, those convicted of crimes of domestic violence. But if it refrains from doing so, their rights remain constitutionally protected. In other words, a person convicted of a qualifying crime does not automatically lose his right to keep and bear arms, but instead becomes eligible to lose it. Notice it's the exact same treatment for both there because Durbin is drooling into his urine cup right now. Next. While scholars have not identified 18th or 19th century laws depriving felons of the right to bear arms, history does show that felons could be disqualified from exercising certain rights, like the rights to vote and serve on juries, because their rights belonged only to virtuous citizens. See Thomas M. Cooley, A Treatise on Constitutional Limitations. Next, we're just going through the list of times she mentions votings. The problem with this argument is that virtue exclusions are associated with civic rights, individual rights that require citizens to act in a collective manner for distinctly public purposes. See Saul Cornell, A New Paradigm for the Second Amendment. For example, the right to vote is held by individuals, but they do not exercise it solely for their own sake. Rather, they cast votes as part of the collective enterprise of self-governance. Similarly, individuals do not serve on juries for their own sake, but as part of their collective enterprise for administering justice. Some scholars have characterized the right to keep and bear arms as a civic right because it was one exercised by citizens, not individuals, who act together in a collective manner for a distinctly public purpose, participation in a well-regulated militia. That is, and she's citing Cornell and Didino. Notice what she's doing. She's just summarizing the existing state of law. She's not actually making the value judgments that Dick Durbin is saying. He is too stupid or dishonest to know the difference. And that's the important part. The assumption you have to make, if these people aren't drooling flatliners walking around in bathrobes, is that they're just lying.
Read it and thought, I can't imagine that she's saying this, but I'm afraid I was left with the suggestion you might. Which brings me to the conclusion here. We hear over and over from the other side of the aisle, we don't want any activist judges. We want judges who are going to go back to the original document, literally take it word for word, put it in historical context, and don't get in the way of making laws. We make the laws, you're a judge, you stay away from them. And yet, when we look at this case, the notion of what disqualifies you from buying a firearm was being rewritten by the dissenting judge and saying, when we say felony, we just mean violent felony. Well, the word violent isn't in there, but you found it, or at least found reference to it. It's not the only time this has happened.
Importantly, she did find it.
Its progeny, Republican-appointed justices struck down bipartisan campaign finance reform to unleash a flood of dark money into our political system. Part of that flood is paying for the ad campaign promoting your nomination for the Supreme Court. I know you've said you've gone radio silent in following the media. I don't blame you. I do the same thing politically. But I can just tell you, I've seen them. They are beautiful, expensive ads.
Beautiful ads, very expensive, really tremendous, really the best ads we've ever seen. Fantastic ads. You've never seen an ads like you've seen on Amy Coney Barrett. She has the best ads I've ever seen. The best ads of any Supreme Court justice. Look, you want to get your hands on the ads of ACB. Really terrific ads. Really, really. 2 handfuls of ads going directly to ACB. Fantastic.
Boosting your nomination for the Supreme Court from organizations we've never heard of. Spending millions of dollars to make sure you get on the Supreme Court. Citizens United opened the door for that. And in Shelby County, conservative justices gutted the Voting Rights Act to unleash a wave of voter suppression across the country, going back to the George Floyd moment.
Durbin's almost done,
Unfortunately, a lot of it is for racial purposes. And this is an example, 2 or 3 examples that I've given here, of activist judges rewriting the law, abolishing the law. People have to get real.
Citizens United, they didn't rewrite the law. Citizens United was was getting rid of one improper restriction on free speech. In fact, all restrictions on donations to political campaigns are an improper suppression of your First Amendment rights. Don't even at me that they're not. There is no constitutional limit on the amount of political speech you can engage in. It's not anywhere. I know. Money in politics, money in politics, money in politics. The people complaining about money in politics are senators and representatives who have the most money in politics because they build up a war chest over 30 years and no one who's challenging their incumbency can touch it because of the restrictions they put on new candidates. And that is just a fact. They never vote to limit their power. If they're passing campaign finance reform, it's only to expand their existing power. Citizens United was improperly decided only to the extent that it didn't completely demolish all campaign finance restrictions. There is no question that a restriction on the amount of money you can spend to promote a candidate is an improper restriction on your right to speech. And if you think otherwise, I'm sorry, you're not correct. I will mansplain the ever-loving shit out of this to whoever tries to say otherwise. Abraham Lincoln was almost entirely funded by one newspaper that is family-owned. His entire campaign, something like 90% of his spending, was funded almost entirely by one entity.
I said to you on our phone conversation, I don't think you put the facts here and the law here and 9 justices come to the same conclusion. Cases are 5-4, 6-3, 7-2 unanimous. People see things differently based on their backgrounds, their values, their experience. And I think it's simplistic to think this is a robotic performance. Once we put a judge on the bench, they just go back, read the Constitution, and rule. It's not that simple. And I think you've acknowledged that by saying even originalists disagree with one another. Is that true?
Yes, law is hard and it's complicated, and people who approach it from different jurisprudential perspectives will sometimes reach different results. I mean, I think that's hard to deny because, as you say, every vote from the Supreme Court isn't unanimous, and sometimes it is, but cases don't get to the Supreme Court unless the circuits disagree among themselves. So it's hard. But to the extent, Senator Durbin, that you're suggesting that I have some sort of agenda on felon voting rights or guns or campaign finance or anything else, I can assure you and the whole committee that I do not.
I didn't say that, and I wouldn't say that.
You did
But
say
I will
that.
say that you come, if you're successful in this pursuit, you come to the Supreme Court with life experiences. You come to the Supreme Court having read a lot, I'm sure, and drawn some conclusions in your own mind about certain things and certain issues. Everyone on the court has that same background. They bring something to it that is just not generic, it's individual. And that's the point I'm making. There's an individualism to this. The class of originalists on the Supreme Court are not all going to vote the same on every case. And I think merely saying originalism
She already
does
laid
not
out that
absolve
Heller they
you
didn't.
or us from observing the obvious. There are going to be differences. I think, would you like to say something? I don't want to cut you off.
No, that's okay.
Okay, thank you very much.
Good job. Good finish there, Durbin. Completely pointless. This is what I'm talking about. What a waste. What a waste. I'm going to queue up the next one real quick. We're going to Amy Klobuchar, and I apologize in advance for exposing you guys to Amy Klobuchar.
Thank you very much.
Oh, shut up. That's gonna be a hard thing, but we've got a couple super chats to go through, and then we'll go back into Amy Klobuchar. I hate campaign finance reform. Like it is one of the most, because it sounds so reasonable. Oh, well, you don't want money influencing politics, do you? Okay, subject the parties to campaign finance reform. Limit the amount of money the Republican Party can give to Donald Trump to $2,400 an election. And limit the amount of money the Democratic Party can give to Biden to $2,400 per election. Why don't campaign finance reform, why don't they apply to them? Why don't they apply to those entities? They're entities. Oh, because that would cut off their funding, right? That would sure bring the Libertarian Party, the Green Party, that would bring them right up on par with Republicans and Democrats, wouldn't it? If the party entities themselves could only hand over $2,500 to the campaign. That'd be a big damn change. They'll never do it. They don't believe in campaign finance reform. They believe in protecting the incumbency. This is why something like 85% of incumbent Congress people retain office. It's why you can't change Congress. They've set up a system to insulate their own power. Never, ever take a politician talking about putting reasonable restrictions on campaign spending. Never take them at their word. Never take them at face value. They're lying. Doesn't matter what side of the aisle, by the way. Citizens United rolled back McCain-Feingold. That's a Republican, Democrat, bipartisan bill, bipartisan legislation from two of the oldest, one of the deadest now, two of the oldest, one of the deadest people in Congress. All right, real quick, let's do these. Bad Vibes says judicial independence. Also the rules for recusal. Okay, so judicial independence means that the justices are free from the influence of politics. They're not elected. They don't have to, at the federal level, they're not elected. They're appointed. They don't have to uphold a party line to maintain their independence. That's what the lifetime, or maintain their position. That's what the lifetime appointments are. At the state level, there are lots of elected judges. In Texas, if you're a Republican judge, if you're not a Republican judge, you may not even get a place. You may not be elected to a district court. And if you are a judge who routinely votes against, say, gun rights or rules against gun rights, you're going to go at the state court level. They'll vote you out. At the federal level, you have judicial independence because you have a lifetime appointment. You're not beholden to anybody. You're actually, your term is going to outlast theirs in many, many cases, especially if it's a presidential appointment, which federal ones are presidential appointments. You are at most, to the extent you are beholden to a president, it is for at most 8 years. But it is also, you're not beholden to them because they can't remove you. They can't remove you once you're in. You can only be impeached for bad behavior or resign on your own. A president can't touch you. So that's the judicial independence that she's talking about. Rules for recusal. I don't know the specific rules for recusal in this case. I've said, she hasn't said specifically whether she'll recuse herself in the instance that the Supreme Court is asked to intervene in the election. I think she will. I don't think she'll say it. I think she will recuse herself. Although after hearing Dick Blumenthal talk, I hope she doesn't. But I think she will. But he was such a cockbag to her that I hope she doesn't. I hope she just goes in and says President Trump is the winner. Just because. Only because of Richard Blumenthal. Other than that, I didn't actually care until I heard him talk because he was so horrible. Nova Zero says, why are your inalienable rights alienable? Exactly. I know you Americans don't quite have the necessary mastery of the English language. It might be the way y'all cobbled together your legal system, but what the hell? It doesn't make sense to me either, bro. Not at all. Where it's like, oh yeah, your right to bear arms shall not be infringed. Unless what? That's not in the text. Keck7 Ghost says, good morning, Pirate Boomer. Arr, shiver me timbers. 1d6 purple worms ahead. Also, Viva Frey stream about Sargon versus obviously stream when? That'd be a good one. I talked to Viva the other day about doing a stream, setting one up. He cannot do the nighttime stream, so I'm going to work on a daytime stream with Viva ASAP. I'm also trying to work on a stream with Sargon as well. Bad Vibe says, listen, Richard Cranium, the average citizen had access to military-grade hardware and explosives and were hand-built. Many craftsmen built impressive weapons. Look up the Puckle rifle. Mithrin Emrys says, bloviating and grandstanding combined with poor understandings and misunderstandings of the law. Gotta love the confirmation process. Seems like a lot of these senators get their law degrees from a Cracker Jack box. Mithrin Emrys says, term limits now. 2 terms for senators, 4 for Congress critters. I agree. Although I would do 3 for House, but that's me. And no more than 14 years combined in both houses. Then we can consider term limits for SCOTUS, say 20 years max. How about this? My dad proposed something to presidential term limits, and I found it very intriguing. I think it's an interesting idea. I wanted to know y'all's opinion. The president can serve for 2 terms, but they must be non-consecutive, so that the president is never campaigning while president. I think that's an interesting proposition right there. They can do their 4-year term. Then another president can get elected for 4 years. Then the other president can run again. That is an interesting proposition. I don't know if I like it or not, but I'm intrigued by it. Our old presidents will be in the grave for their 2nd term. Don't care. Don't care. Yeah, it only happened once, the Lola. But I'm very curious about the prospect. So, what if there's war? Too bad. Less war, please. So it's interesting. It's interesting. Curious about your thoughts. All right. Okay, let's do this. Amy Klobuchar. No, don't do. Oh God, why?
Mr. Chair, welcome again, Judge. Since I have the draw to always follow Senator Cruz, I did want to make one thing clear. after listening to that for a half hour, that Joe Biden is Catholic and he is a man of faith.
Shut
and
up.
Then I want to turn to
Just
something
shut
else,
up.
and that is that we need a reset here, in my mind, for the people at home, a bit of a reality check, that this isn't normal right now.
Oh, you know it's
We
going to be a
have
reality
understand
check
that
when a
what people are
senator's
dealing
talking.
with, that 7.7 million people have gotten this virus, that 214,000 Americans have died. And for people watching at home and wondering what we're all doing in this room right now, and maybe you're home because you lost your job or
God, she is ugly. Okay, let me do this. Let me add some commentary to the artistic value of PBS's productions here, so I can add some hot takes. PBS should not have aired either of these from an artistic perspective, because your artistic subject should be beautiful. So their framing, their camera work was bad. Their cinematography, terrible. They should not have shown Dick Durbin. They should have shown like a serene landscape or something to calm us all while he talked like a moron and rambled on. He had craters in his nose bigger than the craters at Normandy, and it was disgusting. I didn't want to see him. Like I said before, his cheeks were retreating from his brain. The man is hideous. So get your cameraman to look at anything else in the room, like ACB, for example. Or if there's a hot intern somewhere, pick that. Pick that and just voice over Dick Durbin's voice. We don't care. We don't want to see him. In fact, you could just run a display of, like supermodels, male and female, in bathing suits, just playing in the water while Dick Durbin talks. That would be better. That would be better. Please never, ever, ever show these people again. Amy Klobuchar, look at that. Looks like a man. I have a feeling right now Amy Klobuchar is my accountant who's about to tell me about my taxes. And her name is Bill. This is a terrible shot of her. They should shoot her from a wide angle, from maybe 200 miles away, so I can't see her at all. This is disgusting. PBS, you should do better. You should do better. The craft of what you created is inferior to a better artistic work, which would be, say, looking at, I don't know, this cloth back here would be better. All right. Why did y'all vote Amy in office? Don't look at me. Don't look at me.
maybe you got your kids crawling all over your couch
This shot,
right now.
way better. Oh my
maybe-
goodness. Let me be critical real quick. This shot is a much better shot of Amy Klobuchar than the last one. The framing in this is much better. I think this technique is great. There's my critical analysis of it. Now we're in fair use territory.
You're trying to teach your first grader how to do a mute button to go to school. Or maybe you've got a small business.
Why do you need a mute button to go to school?
Yeah, to close down or that's struggling. We should be doing something else right now. We shouldn't be doing this. We should be passing coronavirus relief.
No, you should be doing this because this is what you are supposed to do, because not because of the Constitution or anything like that, but because the president appointed a nominee and the head of the Senate Judiciary Committee decided you should do it. That's the process you have. If you want it different, rewrite the rules of the Senate, coward. Write a rule that says that you can't do this in an election year. But you won't, because if it's an election year and you control the Senate and you have a Democrat president, you would do the exact same thing. I'm so tired of the posturing on this. It's so dumb. Both sides, but mainly the Democrats. At least the Republicans are honest that they were hypocrites. They're like, yeah, of course. We said that then. We believe differently now. Bite me. We have the authority to do it. Rewrite the rules of the Senate. No one can stop. Only the Senate can do it. Only them, literally them, can do it. The justices can't do it. The president can't do it. The House can't do it. Only the Senate. They write their own rules, and they're bitching about their own rules.
Like the House just did, which was a significant bill that would have been a big help. And I think people have to know that right now.
We don't have to know it.
And whether you're Democrat, Independent, or Republican. And that's why I started out yesterday by telling people that they need to vote. Number two,
They need to vote you out. You're awful.
some of my colleagues throughout this hearing on the other side have been kind of portraying the job that the judge is before us on.
This is unrelated to what she's saying. Listen. Like, I don't like to be stereotypical, but Amy Klobuchar has a stereotypical woman jealous bitch moment. Pardon my expression. She has it in this hearing. When you hear it, spam the chat with like 1 or B word or whatever. Just do it. When you hear that moment, it's coming.
As being some kind of ivory tower exercise. I think one of my friends called it, related that you'd be dealing with the Dormant Commerce Clause. Well, I'm sure that might be true.
She will be dealing with the Dormant Commerce Clause. No, it hasn't happened yet. But it's why the flipping Obamacare decision that you're going to bitch about for the next hour exists.
But we also know that this is the highest court in the land, that the decisions of this court have a real impact on people. And I appreciated, Judge, that you said that you didn't want to be a queen. I actually wouldn't mind being a queen around here, if the truth be known. I wouldn't mind doing it, and kind of a benevolent queen and making decisions. So
vote her out. Vote her out. She's a tyrant. Vote her out. She just said it.
we could get things done. But you said you wouldn't let your views influence you and the like. But the truth is, the Supreme Court rulings, they rule people's lives. They decide if people can get married. They decide what schools they can go to. They decide if they could even have access to contraception.
That's not it either, by the way.
All of these things matter. So I want to make that clear. And the third reset here that I think we need to have is that this hearing is not normal. It is a sham. It is a rush to put in a justice.
This is so insulting to ACB, by the way.
Vacancy so close to an election was when Abraham Lincoln was president. And he made the wise decision to wait until after the election. The last time we lost a justice so close to an election. That's what he did. Today, we are 21 days from the election. People are voting. Millions of people have already cast their ballots. And I go to the words of Senator McConnell. The last time we had a situation in election year, he said, the American people should have a voice in the selection of their next Supreme Court justice. Therefore, this vacancy should not be filled until we have a new president. That set the precedent that so many of you...
It's not precedent, by the way. And he said the next Supreme Court justice. He didn't say anything about the next 3 Supreme Court justices. He just said that one.
You have embraced, or at least you did a few years ago, and that is that in an election year, the people choose the president, and then the president nominates the justice. So why is this happening? Well, that's a good question. This guy, our president, he is the one that decided to plop a Supreme Court nomination in the middle of an election when people's health care is on the line with a case before the court on November 10th. So let's see what he said about the Supreme Court. Well, one of President Trump's campaign promises in 2015 was that his judicial appointments will do the right thing on Obamacare. You can see it right here. And in fact, Judge, just one day after you were nominated, this is like a few weeks ago, he said also on Twitter
what does that mean,
it would be
Amy?
a big win if the Supreme Court strikes down the health law.
That would be a big win for
Judge,
Trump.
my first question,
that would
do
be
you
a
think we
huge
should
win for
take the
Trump.
president at his word when he says his nominee will do the right thing and overturn the Affordable Care Act?
Senator Klobuchar, I can't really speak to what the president has said on Twitter. He hasn't said any of that to me. And what I can tell you, as I have told your colleagues earlier today, is that no one has elicited from me any commitment in a case or even brought up a commitment in the case. I am 100% committed to judicial independence from political pressure. So whatever people's, party platforms may be or campaign promises may be, the reason why judges have life tenure is to insulate them from those pressures. So I take my oath seriously to follow the law. And, I have not pre-committed, nor would I pre-commit to decide a case any particular way.
Okay, and I think this life tenure, this idea that you have, just for everyone out there, a job for life, makes this even more important for us to consider.
You basically have the Senate job for life, so shut up.
You have not said how you would rule on this case that's coming up right after the election, where the president had said it would be a big win if the Supreme Court strikes down the law. But you have directly criticized Justice Roberts in an article in my own state in one of the Minnesota Law School journals.
She actually
did. It was in 2017. It was the same year you became a judge. And when Roberts writes the opinion to uphold the Affordable Care Act, you said he, quote, pushed the Affordable Care Act beyond its plausible meaning to save the statute. Is that correct?
Senator Klobuchar, I just want to clarify, is this the constitutional commentary publication that you and I discussed?
Yes, it is.
Okay.
It is, but it's still a
No,
University of Minnesota law. Yes.
Okay, I just wanted to be sure because I hadn't published in the Minnesota Law Review.
Again, did you ask that question? Did you say that he pushed the Affordable Care Act beyond its plausible meaning to save the statute?
One thing I want to clarify is you said that I criticized, Chief Justice Roberts, and I don't attack people, just ideas. So that was just designed to make a comment about his reasoning in that case, which as I've said before, is consistent with the way the majority opinion characterized it as the less plausible reading of the statute.
Okay, so you didn't agree with his reasoning in the case that upheld the Affordable Care Act?
What I said.
Real quick. This is quoting Roberts. The most straightforward reading of the mandate is that it commands individuals to purchase insurance. After all, it states that individuals shall maintain health insurance. Congress thought it could enact such a command under the Commerce Clause, and the government primarily defended the law on that basis. But for the reasons explained above, the Commerce Clause does not give Congress that power. Under our precedent, it is therefore necessary to ask whether the government's alternative reading of the statute, that it only imposes a tax on those without insurance, is a reasonable one. She's literally giving the reasoning that John Roberts gave himself. She's not criticizing Roberts's decision. She's using his own criticism of the text of the statute.
And was this King versus Burwell or NFIB versus Sebelius?
That was NFIB versus Sebelius. I'll get to King versus Burwell in a second.
Okay. What I said with respect to NFIB versus Sebelius is that the interpretation that the majority adopted, construing the mandate to be a tax rather than a penalty, was not the most natural reading of the statute.
But it was still the reading that Justice Roberts got to. Now, you also criticized...
Yeah, but he even said it was the less natural reading. I just read the passage to you. God. Bad Vibe says, let me suggest that PBS is handicapped by public government funds. PBS actually had to earn its money from content. They couldn't buy a case of ramen. He also says, what you can take from this rant, you didn't give us our way when you controlled the Senate with Obama. Now you can do what you want because you control the Senate under Trump. Someone call this whiny witch a wambulance. Thank you. Thank you for that. Let's keep going.
It's just you pointed out by bringing up King v. Burwell, another case where the court ruled in favor of the health law. This was in a 2015 National Public Radio interview. And you acknowledged that the result of people being able to keep their subsidies under the Affordable Care Act would help millions of Americans. Yet you praised the dissent by Justice Scalia, saying the dissent had, quote, the better of the legal argument. Is that correct?
I did say that, yes.
Okay.
Yes,
so then
it's a legal argument, not a policy
the same
one.
way and voted with Justice Scalia?
Well, Senator Klobuchar, one of the plus sides or the upsides of being an academic is that you can speak for yourself, that a professor professes and can opine, but it's very different than the judicial decision-making process. So it's difficult for me to say how I would have decided that case if I had to go through the whole process of judicial decision-making that I was describing this morning, now, having been a judge for 3 years, I can say I appreciate greatly the distinctions between academic writing or academic speaking and judicial decision-making, such that a judge might look at an academic and say, easy for you to say, because you're not on a multi-member court, you're not constrained by stare decisis, you don't have real parties in front of you, consulting with litigants, consulting with your clerks.
Yes.
It's just a different process.
I viewed this one so interestingly because you were commenting on the public policy result, which you and my colleagues on the Republican side have said this shouldn't be about public policy, and you said, okay, that's okay, but then you were really clear on your legal outcome in terms of your view of whose side you were on. You were on Scalia's side, and of course, that was a side
No, she said he had the
to
better
not
legal
uphold
argument.
the Affordable Care Act, which would have been kicked millions of people off their health care in effect because they would have lost their subsidies. And I just see this as interesting because of this kind of dichotomy they're trying to make
I bet
between
Klobuchar has
policy
never
and
even
legal.
read
And
the
my
Affordable
view
Care Act.
is that legal decisions affect policy. I mean, I'm looking at people in my state that'll deal with this if the Affordable Care Act is struck down. Elijah from St. Paul, who was
Shut
born with
up.
cerebral palsy.
No one cares
because of
about
the Affordable
Elijah.
Care
I'm
Act.
sorry.
He is now 16 and is a proud Boy Scout. Casey, whose brother lives in Alexandria, and his chronic kidney failure.
No one
and
cares
he
about
needs a
Casey. I'm
transplant.
sorry.
Without the ACA.
It's not relevant to this.
That'd be that. Or Burnett from the suburbs of St. Paul, whose daughter has multiple sclerosis, depends on benefits under the ACA. Liliana of Fridley, who has a 21-year-old son with autism and needs her children to be able to stay on her insurance until she's 26. Melanie, a senior from Duluth, who's being treated for ovarian cancer and needs access to the Affordable Care Act. So my point is that these are real-world
There's no other way to
situations.
get
And
these
so
people insurance other than this
I get that you're not saying how you'd
monster of a
rule on
law.
these cases. So what does that leave us with here to try to figure out what kind of judge you would be? And I was thinking last night of when I was growing up, we would go up to northern Minnesota, and we
Oh my God,
didn't
shut
have a
up.
cabin, but we had friends that did. And we would go on these walks in the woods with my mom, and she loved to show all the
This is the most
tracks
pointless
on that path,
talk ever.
whether they
Socialism
were,
is for Fig says,
deer
my parents had to
tracks,
get a
and she'd have us
divorce
figure
because
out
of the
what they were,
Affordable
or
Care
elk,
Act,
or maybe
because of
even
how
a
it is
bear.
run.
And we would follow
Yes,
these
it's
tracks down that
trash.
path. And you'd always think, is there going to be a deer around the corner that we're going to see?
No.
And very rarely was there one.
Never.
But we
Never
would
was there
follow
one.
the tracks. And so when I look at your record, I just keep following the tracks. That's what I've got to do. And so when I follow the tracks, this is what I see. You consider Justice Scalia one of the most conservative judges in the history of the Supreme Court as your mentor. You criticize the decision written by Justice Roberts upholding the Affordable Care Act.
She
that is,
didn't.
to me, one big track. Even if you didn't consider yourself
Not even criticizing it.
him personally, you criticized the reasoning. You then said in another case about the Affordable Care Act that you would that you liked the legal reasoning, that he had the better legal argument, that Justice Scalia had the better legal argument. You have signed your name to a public statement featured in an ad, a paid ad, that called for an end to what it called, the ad called, the barbaric legacy of Roe v. Wade, which ran on the
not her
anniversary
ad.
of the 1973 Supreme Court decision. You disagreed with long-standing precedent on gun safety, which said that felons shouldn't be able to get guns, something that was pretty important to me when I had my old job in law enforcement. This is something that Senator Durbin asked you about. You suggested that you agree with the
Reminder that Amy Klobuchar had the opportunity to prosecute Derek Chauvin and she didn't. Just a reminder that she had the opportunity to prosecute Derek Chauvin. If it were not for Amy Klobuchar, George Floyd would be alive today. All she had to do was prosecute Derek Chauvin. And then Mr. Neon Neck wouldn't have been there. Wouldn't have been there to kill Floyd. That's it. I got to read a couple chats real quick. Mithran Emrys says, come on, Nick. After the ACA passed, insurance rates went down, medicine became cheaper, dogs lay down with cats. Oh, wait, none of that happened. Insurance rates skyrocketed. The cost of medicine skyrocketed. Look, the first year that the ACA took effect, health insurance for my family went from $430 a month without me on it to over $900 a month without me on it. With me on it, it would go up to thousands of dollars a month, or over $1,000 a month. That was the first year. It has gone up significantly since then. Bad Vibe says, take note, folks. We must steal from Peter to pay Paul's healthcare. Oh, and by the way, deductibles went up. Deductibles went up and copays went up as well. We must steal from Peter to pay Paul's healthcare because Congress has made rules and regulations that cause prices to skyrocket. Exactly. Exactly. Look at this goblin. Oh, what a monster.
Dissent in the marriage equality case, Obergefell, that it wasn't the role of the court to decide that same-sex couples had the right to be married. I think this was in a lecture you gave where
it's
you
not the role of the
said,
courts to decide
dissent's
that.
view was that it wasn't for the court to decide. People
really
could
isn't.
lobby in state legislatures. And all this takes me to one point as I follow those tracks.
I don't even
down
care
that
if
path.
gays get married, but it's not the court's job.
It takes me to this point where I believe, and I think the American people have to understand that you would be the polar opposite of Justice Ginsburg.
Thank God.
She and Justice Scalia were friends, yes, but she never embraced his legal philosophy.
And that's why she was a worse justice
So that is
than him.
what concerns me. And I want to turn to an area where I think Justice Ginsburg, whose seat we are considering you for, was truly a...
No, 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 no. It is not Justice Ginsburg's seat. It was not Antonin Scalia's seat. It was not Justice Kennedy's seat. The justices do not own the seat. The seat is just a seat on the Supreme Court. It is no one's. There is no legacy to fill. There is no history attached to the seat. It is merely just a seat. Stop it.
Hero, and that was the area of voting rights. And that was the area of elections. I think that, what did the president say here? He said, September 23rd, 2020, I think this, he means the election, will end up in the Supreme Court. And I think it's very important that we have 9 justices.
It is important to have 9 justices on the Supreme Court for a matter as important as the integrity of the election. That is not a controversial statement, because a 4-4 split would be a problem because it would literally matter who filed first. Who filed first would matter over the merits on a 4-4 split. President Trump is not wrong in that.
I don't think how much clearer we can be. And as I said yesterday, I do not for a minute concede that this election is going to end up in the Supreme Court because people are voting in droves as we speak. But that is what...
You're a liar. All of you think this is going to the court. You all know it is. You all know it is.
...is on the mind of the man who nominated you for
No,
this
it's on
job.
all of your
Then he
minds.
said, on September 29th of 2020, I think I'm counting on them, he meant the court, to look at the ballots indefinitely.
Good.
So, I know you said earlier in questions from Senator Leahy that you are not going to commit to whether or not you are going to recuse yourself for any kind of an election case.
Because
But
it depends on the case.
I do want to point out that as the president has said these things, and as he has nominated you, that people are voting right now. They are voting, as I said, in droves. Do you know how many states where people are voting right now, Judge? I think one of my colleagues said it earlier.
I don't know.
It's more than 40 states. People are voting right now as we speak. I think something like 9 million votes have been cast. Do you think it is faithful to our democratic principles to fill a Supreme Court
8 million of those have been
vacancy
cast in Ilhan
this
Omar's district.
close to an election when people are still voting?
Senator Klobuchar, I think that is a question for the political branches.
Okay.
It is. It is not the role of the judiciary to determine whether or not it's appropriate for the president to enact his constitutional power. That is a political question. Amy Klobuchar would know this as the political question doctrine. If you tried to get the court to rule on this, they would say that's a political question. Elections have consequences. And if you don't like the way that Trump is handling it, vote him out.
That's your right to answer in that way.
That's the correct answer.
Beyond this immediate election, I want to turn to the Supreme Court's critical role when it comes to the right to vote, this area where Justice Ginsburg was such a champion. Senator Durbin went over your dissent at length in Cantor v. Barr, where you drew a distinction between individual rights and civic rights.
No,
and
the
you
court
wrote
did.
that historically, felons should be disqualified from exercising certain rights, like the right to vote and to serve on juries.
She did not say they should. She says they have.
So my question is this next line where you said these rights belonged only to virtuous citizens. What does that mean?
Senator, I would need to look at the article to clarify, but as I'm sitting here, I don't think I said felons should lose voting rights. I think what I was talking about is that 14th Amendment. Yeah, that.
But it wasn't an article, just to be clear, right? This is your dissent.
Oh, my dissent.
Yeah, I think it's your dissent in Cantor v.
Yes.
Okay, real quick. Here it is. Perhaps the most accurate way to describe the dominant understanding of the right to bear arms in the founding era is as a civic right. She's quoting Cornell and Didinio, Fordham Law Review. Such a right was something that all persons could claim, but was limited to those members of the polity who were deemed capable of exercising it in a virtuous manner. Freedom of religion, freedom of the press, trial by jury were genuinely rights belonging to individuals and were treated differently than were civic rights, such as militia service, the right to sit on juries. And as a right that was exercised for the benefit of the community, like voting and jury service, rather than for the benefit of the individual, like free speech or free exercise, it belonged only to virtuous citizens. Amy Klobuchar is actually reading this wrong, because in this article she's talking about, they're talking about the right to bear arms as a civic right. Klobuchar is too dumb to understand that she's making the opposite argument. Amy Klobuchar, you are stupid. Learn to read. The article, the law review article she's quoting says that the right to bear arms is a civic right along with the right to vote, distinguishable from the right to religion and the right to free speech. She's saying the literal opposite of what you're saying. You're too stupid to recognize it. Go back to law school and then quit.
You're right.
And it says felons could be disqualified from exercising certain rights, like the rights to vote and serve on juries. But apart from that clause, you said these rights belong only to virtuous citizens. That's what I'm trying to understand what that means.
So the argument in the case, those who were challenging Heller and those who were arguing on the side of the government in the Cantor case is that the Second Amendment is a civic right. And that is how the Supreme Court itself framed the debate, as a distinction between civic rights and individual rights, with voting being a civic right. And in literature, in the historical literature, which was at play in that case.
Okay, but how would you define the word virtuous? Because it doesn't appear in the Constitution.
Well, Senator,
it's not her word. She didn't use it. It's in the text.
To know what that means, because we're living at a time where a lot of people are having their voting rights taken away from them. So what's virtuous?
Okay, well, Senator, I want to be clear that that is not, in the opinion, designed to denigrate the right to vote, which is fundamental. The distinction between civic and individual rights is one that's present in the court's decisions, and it has to do with a kind of a jurisprudential view of what rights are. And the virtuous citizenry idea is a historical and jurisprudential one. It certainly does not mean that I think that anybody gets a measure of virtue and whether they're good or not and whether they're allowed to vote. That's not
Okay.
what I said.
Okay, now let me ask you this in a different way, because now let's go to the real world here. So
Let's go to
in
the real
Justice
world, not the real
Ginsburg's
case you
dissent in
did.
Shelby, where a 5-4 court struck down a key provision of the Voting Rights Act, she described the right to vote as a fundamental right in our democratic system. And I assume you agree with this, because you just said that, let's not get to her dissent. You agree with the concept that it's a fundamental right, because you just
As I just said, yeah, the court has repeatedly said it was
Okay,
fundamental.
so she also wrote in her dissent that the Constitution uses the words right to vote in 5 separate places, the 14th, 15th, 19th, 24th, and 26th amendments. Each of these amendments, this is still her talking, not me, each of these amendments contains the same broad empowerment of Congress to enact appropriate legislation to enforce the protected right. The implication is unmistakable. Under our constitutional structure, Congress holds the lead rein in making the right to vote equally real for all U.S. citizens.
Congress, not the judiciary.
Do you agree with Justice Ginsburg's conclusion that the Constitution clearly empowers Congress to protect the right to vote?
Well, Senator, that would be eliciting an opinion from me on whether the dissent or the majority was right in Shelby County, and I can't express a view on that, as I've said, because it would be inconsistent with the judicial rule.
Okay, so here's my problem. So you go out of your way in the case that Dick Durbin was discussing to make this distinction between voting rights and gun rights.
Look at ACB's face, because she didn't go out of her way. She just wrote the appropriate opinion for her dissent. But that was also her case and her words. Now, we haven't seen this, but all day she's been telling them it is improper, as stated by Ginsburg, Sotomayor, Kagan, every nominee that has recently sat. It is improper for them to issue an opinion on whether or not a particular case was decided correctly or incorrectly. It is not the role of an incoming justice to issue an opinion on the propriety of the decision. She's said it many times already, and she will say it many times again.
But now you won't say whether or not you agree with Ginsburg. And so my view is, just based, again, following those tracks on this case, that you are most likely with the majority. But I know you're not going to answer this. But what I do want you to know is
She
this.
can't.
And this is where it gets interesting because of what Justice Ginsburg predicted in that dissent. According to the Brennan Center, over 20 states since that case came out that withdrew, that took away part of the protections from the Voting Rights Act, over 20 states have now made more restrictive voting laws than they did before that case. Doesn't that suggest to you that Justice Ginsburg had the better of the argument when she wrote that throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you are not getting wet? Do you think that
If you're not getting wet and you have an umbrella and you want to be wet, you should throw away the umbrella. I think she probably misquoted Ginsburg there because as much as I think Ginsburg was terrible, she wasn't an idiot. Klobuchar is. Klobuchar's an actual idiot. Ginsburg was pretty smart. I just disagreed with her perspectives on it. And I think she actually misquotes Ginsburg. I'm not gonna go look it up. If Ginsburg botched that analogy, then she did. I doubt it.
that's true? And I mean, it seems to me that the proof is in the pudding. Like basically, this rainstorm that she said would come has come with all these states, including a number of them that my colleagues over there represent, have enacted stricter laws. Has it happened?
Senator Klobuchar, I want to clarify, you said I was answering Senator Durbin's questions about the Second Amendment, but refusing to answer yours. And so I just wanted to clarify that I have written Cantor versus Barr, and so that's why I was talking about it. But since I didn't write Shelby, I can't really talk about it. So anything that I've written about or talked about, I would be happy to answer your questions.
Okay. All right. But again, it just seems to me you are out of your way on that case. And this is a case that is so real for so many people right now. And that while you can say it's a fundamental right, the issue is that this case and the Voting Rights Act are so key. And let me just say why. We're talking about the entire foundation of our democracy here. For centuries,
We don't have a democracy, we have a republic.
Americans have fought and died to protect the right to vote.
No, they have not. No, they have not. Fought and died to protect the right to vote for centuries. Try and find it. Try and find the war where soldiers fought and died to protect the right to vote.
And so what matters is not just what you say about its being fundamental, it's what you do. States like South Carolina, Texas, North Carolina, Louisiana, Tennessee have policies that make it harder for people to vote. And it's a real world thing before the Supreme Court. In fact, back in May, when voters in Wisconsin were standing in line in the middle of a pandemic, in homemade masks, in garbage bags, in the middle of a rainstorm, just to exercise their right to vote, 70 of them got COVID. Because we didn't know enough about it back then.
Get COVID! Get wrecked!
The president had told us what he knew, and we didn't know enough to protect those voters. So it ends up at the...
In May? In May! You didn't know enough in May? Because the president... Is that what she said? In May?
Supreme Court. What did Justice Ginsburg do? When the Republican-appointed majority on the court ruled that voters in Wisconsin could not have more time to get their ballots in during the pandemic, she called them out in her dissent, in her blueprint for the future. And she said the majority opinion boggled the mind.
Did her blueprint for the future
So
involve
what
dying?
boggles my mind? Well, 2 weeks ago, the U.S. Supreme Court reinstated the South Carolina requirement that mail-in ballots must have witness signatures in the middle of a pandemic. You got to go and get a
Everywhere, Democrats want to remove any barrier to mail-in voting. Any check on it at all, they want to remove all of it.
witness. In Texas, Republicans have argued that the pandemic wasn't a good enough reason to let people under age 65 vote by mail, despite the fact that over 42,000 Americans under 65 have died from COVID. And the governor right now is forcing that state to have only one ballot box
160,000
per county,
COVID deaths.
including in
170,000
Harris
COVID
County,
deaths.
where there are 4.7 million
Are over
people.
65.
And for those of you that thought a judge took care of it a few days ago, he did. But then yesterday, 3 Trump-appointed
Augusto Pinochet asked me what my opinion on voter ID laws is. Take a semen sample. Verify it. Verify it. ID the shit out of everybody. I don't care at all. Almost every Western country on the planet has a voter ID requirement. The U.S. isn't allowed to. And it's the dumbest thing on earth. I want a government jerk off so I can vote. That's what I want. That's what I want. Have you seen the machines they're sending out to the sperm donation clinics? It's literally like a fleshlight. Like you walk up to the glory hole and it just blasts one out for you. You don't have to do any work. You're just like, all right, baby. Like I want that at the voting booth. And then I want some jerk who has to sit there and bleach it down after every use. Do it. I don't care at all. Socialism is for figs says that officer didn't kill Floyd. The bag of drugs he swallowed did. Listen, I was making a point. Sorry, Pally would have died no matter what. Look, I was making a point. Klobuchar is terrible. Mithra Emmer says, can someone please just get the manager for this whiny Karen already? Sweetie Pumpkin, the executive exercises power. Now the Senate is getting to do the same. If only the Dems hadn't changed the rule for seating a judge. Yep, that's your own fault. Bad Vibe says, consider what this narwhal is saying. You don't have the right to personal and local defense if you do X. However, you have a right to vote for people to remove someone else's rights. And Loric Project says, blueprint for the future. Sounds very much like one party state's economic plan. All right, let's go.
appointed judges came in and reversed that. So we're back to one ballot box for people to drop their ballots off in a county of 4.7 million people. In Tennessee, Republicans have tried to prevent ballot drop boxes. I know we had the Secretary of State as one of our witnesses at a Rules Committee hearing, and they have argued in court that COVID-19 is not a valid excuse to vote by mail. In North Carolina, the Supreme Court struck down a core component of the Voting Rights Act. What happened? Well, states like North Carolina passed laws that were so egregious to make it harder to vote that the Fourth Circuit struck down their law and noted that it targeted African Americans with almost surgical precision. So that is what the stakes are. And that is why not having Justice Ginsburg on the court right now is so frightening to so many Americans out there. And that is why we are asking you these questions about voting. So let me turn to another election question, gerrymandering. In 2015, Justice Ginsburg wrote the majority opinion in Arizona State Legislature the Arizona Independent Redistricting Commission, holding that it was constitutional for the people of Arizona to amend the state constitution to establish an independent redistricting commission. Because of this case and Justice Ginsburg's opinion, many argue now that Arizona has fairer electoral maps.
I wonder what Razorfist would say.
Here's your example. And now Justice Ginsburg and Justice Kennedy are no longer on the court.
But Kennedy was considered by many to be of the conservative batch. So you can't just, well, Ginsburg's not on there, and neither is Kennedy. Kennedy isn't part of your argument. Ginsburg is.
My question is this: must state legislatures abide by their own state's constitution when exercising their authority under the Elections Clause?
Senator Klobuchar, that would be eliciting an opinion from me about whether I agreed or disagreed with the result in that case.
Okay, is it constitutional for voters to amend a state constitution to establish specific processes for elections, like the voters in Arizona did to stop gerrymandering?
Again, you're asking me for a view on that particular case, and Justice Ginsburg herself gave the most famous articulation of the principle that constrains me from doing so, which is no hints, forecasts, or previews. So I can't express a view on precedent or on how I would decide any question that was provoked by the application of that precedent to a later case.
Okay, last week a contractor from outside of my state of Minnesota started recruiting poll watchers with special forces experience. To protect polling locations in my state. This was clear voter intimidation.
It's not
Similar
clear.
efforts are going on around the country, solicited by President Trump's false claims of massive voter fraud, something that, by the way, many Republican leaders, including Michael Steele, the former head of the Republican Party,
Why is Barrett
Ridge,
so far to the left in the frame?
Including sitting Senator Romney, have made very clear is not true. So as a result of his claims,
get a shock mount for your mic, you heathen.
Poll watchers, special forces people to go to the polls. Judge Barrett, under federal law, is it illegal to intimidate voters at the polls?
Senator Klobuchar, I can't characterize the facts in a hypothetical situation, and I can't apply the law to a hypothetical set of facts. I can only decide cases as they come to me, litigated by parties on a full record after fully engaging precedent, talking to colleagues, writing an opinion. And so I can't answer questions like that.
Okay, well, I'll make it easier. 18 U.S.C. 594 outlaws anyone who intimidates, threatens, coerces, or attempts to intimidate, threaten, or coerce any other person for the purpose of interfering with the right of such other person to vote.
Good.
This is a law that has been on the books for decades.
Tell that to the Black Panthers.
Do you think a reasonable person would feel intimidated by the presence of armed civilian groups at the polls?
Senator Klobuchar, you know, that is eliciting, I'm not sure whether to say it's eliciting a legal opinion from me, because the reasonable person standard, as you know, is one common in the law, or just an opinion as a citizen, but it's not something really that's appropriate for me to comment on.
Okay. Here's one that I think is selection of electoral college electors.
It's not appropriate at all, you
each
dummy.
state has laws that dictate how electoral college electors are selected. Judge Barrett, in 1932, the Supreme Court in Smiley v. Home, a case involving my state, ruled that the Minnesota State Legislature could not change election rules unilaterally. Do you agree that the unanimous opinion in Smiley v. Home, which has never been questioned by any other Supreme Court case, is settled law?
Well, I'll say two things about that. First of all, I was not aware of that case, so you've taught me something.
Okay.
But secondly, I can't comment on the precedent, give thumbs up or thumbs down in Justice Kagan's words.
Okay, well, why don't we end there with precedent? I think that's a good way to end here. So you wrote in your 2013 Texas
Frankly,
Law
a good
Review
way to end would
article,
start with a
that
bridge
you tend
for
to
you.
agree with the view that when a justice's best understanding of the Constitution conflicts with Supreme Court precedent or case law, it is, quote, more legitimate for her to follow her preferred view rather than apply the precedent. And I want to run through a few examples. So Brown v. Board of Education, as we know, that holds that the 14th Amendment prohibits states from segregating schools on the basis of race. So is that precedent
But yes,
that can't be overruled?
well, that is precedent. And as I think I said in that same article, it's super precedent. People consider it to be on that very small list of things that are so widely established and agreed upon by everyone. Calls for its overruling simply don't exist.
Okay. Well, you also separately acknowledged that in Planned Parenthood v. Casey, the Supreme Court's controlling opinion talked about the reliance interest on Roe v. Wade, which it treated in that case as super precedent. Is Roe a super precedent?
How would you define super precedent?
I might have thought someday I'd be sitting in that chair. I'm not. I'm up here, so I'm asking you.
Okay, well, people use
Did you catch it? Did you catch it? Did you hear it? We're going to go back. We're going to go back. Did you catch it? It was my time. This woman would be a catastrophe on the court. A catastrophe. And she thought she would be a Supreme Court nominee. An absolute embarrassment going on screen right now. And she thought, well, I thought it would be me. Never, ever could it be you.
Precedent. Is Roe a super precedent?
How would you define super precedent?
I might have thought someday I'd be sitting in that chair. I'm not. I'm up here, so I'm asking you.
Okay, well, people use
You
super
won't.
precedent differently.
Okay.
The way that it's used in the scholarship and the way that I was using it in the article that you're reading from was to define cases that are so well settled that no political actors and no people seriously push for their overruling. And I'm answering a lot of questions about Roe, which I think indicates that Roe doesn't fall in that category. And scholars across the spectrum say that doesn't mean that Roe should be overruled, but descriptively it does mean that it's not a case that everyone has accepted and doesn't call for its overruling. I don't
Okay,
think
so here's what's interesting to me. You said that Brown is, and I know my time is running out, is a super precedent. That's something the Supreme Court has not even said, but you have said that. So if you say that, why won't you say that about Roe v. Wade, a case that the court's controlling opinion in that Planned Parenthood v. Casey case has described as a super precedent? That's what I'm trying to figure out.
well, Senator,
Because people call for the overturning of Roe v. Wade every day, and no one calls for the overturning of Brown versus Board. She gave you the answer. It's not even a hard one. It's not even difficult. The fact that you're focused on Roe v. Wade in this hearing is because people want to overturn Roe v. Wade. That's it. If people wanted to overturn Brown v. Board, you'd be focused on that. But no one does.
can just give you the same answer that I just did. I'm using a term in that article that is from the scholarly literature. It's actually one that was developed by scholars who are, you know, certainly not conservative scholars, who take a more progressive approach to the Constitution. And again, you know, as Richard Fallon from Harvard said, Roe is not a super precedent because calls for its overruling have never ceased, but that doesn't mean that Roe should be overruled. It just means that it doesn't fall on the small handful of cases like Marbury versus Madison and Brown versus the board that no one questions anymore.
Is United States v. Virginia military?
Real quick. I'm going through Planned Parenthood versus Casey right now. The word super does not appear next to the word precedent in the entire opinion. It is not a super precedent. The word super appears twice. Pennsylvania Superior Court is one of them. And the other one is because they perceive no superior alternative. Amy Klobuchar is wrong yet again, and all it took was a 2-second control F on the case. They do not refer to Roe v. Wade as a super precedent in Planned Parenthood versus Casey. You dummy.
Is that super precedent?
Senator Klobuchar, if you continue to ask questions about super precedents that aren't on the list of the super precedents that I discussed in the article that are well acknowledged in the constitutional law literature, every time you ask the question, I will have to say that I can't grade it.
Okay. Well, I am then left with looking at the tracks of your record and where it leads the American people. And I think it leads us to a place that's going to have severe repercussions for them. Thank you.
All right, so there's that. There's that. Hold on, I'm composing a tweet to Amy Klobuchar because I just want to point out to her a fun fact. Hey, Amy Klobuchar, fun fact. Planned Parenthood v. Casey does not include the phrase super precedent in additional wait, no, I'll just leave it at that, just FYI. I mean, she prepped for that. That was a prepared remark. They referred to it in Planned Parenthood versus Casey as a super precedent. They literally didn't. They did not do that. Okay, let me get the last one up. Remember, we're gonna watch Kamala Harris's ones, and that one will be a live react for me. I've seen the other ones. I've not seen Kamala Harris, and I thought that would be fun for us to do. And by fun, I mean I'll want to eat a bunch of dirt and garbage afterwards. But I have to take 1 second to go to the bathroom because I'm drinking Gatorade. Sorry. All right. Let me read these couple first. Caloric Project says Klobuchar needs to go cry in the corner. So frightening. Nova Zero says, is Klobuchar crying? I mean, it's not just me, right? She's crying. And Nick, when you say jerk, are you referring to the common jerk or the federal jerk, like clerk administrator job that you're proposing? Yes. And Michael Tynan says, Amy, can you reach her with your Starbucks? Yeah, throw the Starbucks at her. Do it. All right, I'll be back. I got to hit the bathroom. We'll be right back. Bearcoon, don't let me down. All right. Sorry about that. Okay, here we go. We're going to jump into this last one. Kamala Harris.
Floor is yours, Senator Harris.
God,
Thank
she's
you, Mr.
hideous.
Chairman. First, I want to extend
Go to Washington. What is wrong with you? You can't be there?
greetings to Judge Barrett, and I look forward to our conversation this evening.
Thank you, Senator.
No one else does.
Thank you. Before I begin, I want to just take a moment to talk directly with the American people.
No,
about where we
please.
are
Please
and how we
don't.
got here.
No one cares.
So we are in the middle of a deadly pandemic.
It's not that
has
deadly.
hit our country harder than any other country in the world. More than 200.
I don't believe so. I do not believe that to be true. I don't care what you say. It's like infant mortality rates. We report them, other countries don't. It doesn't mean we have higher infant mortality than Zambia. It just means that we actually report infant mortality. Seamus Mallon says, how frustrating must it be to sit there and listen to drooling idiots accost you of stuff that is untrue, wrong, and doesn't even make sense? Well, I have, not to say that I'm on the same level as ACB, but I have endured law Twitter on Twitter. So it's frustrating.
115,000 of our fellow Americans have died, and millions more, including the president, Republican members of this committee, and more than 100 frontline workers here at the Capitol complex have been infected. This pandemic has led
She is
to
quintessentially
an historic economic
unlikable.
crisis, causing millions of workers to lose their jobs without warning, and 12 million Americans have lost their employer-based health insurance. The Senate.
They lost it because of people like you. People like you want to shut down the economy. That's why they lost their jobs and their health insurance. It's people like you. If I was in charge, there would have been no shutdown. I'd have been like, you walk up to your neighbor's house, you open their mouth, and you cough in it immediately. Get it out of the way. Get it done. Rip the Band-Aid off. Let's go. We got work to do. Make the widgets. Loric Project says, a Camel, a Harris, such a disgrace. Senators not in the room shouldn't get to join in on the hearings.
I strongly believe must be and needs to be laser focused on you, the American people, to help you get through this pandemic. To do so, the Senate urgently needs to pass critical financial relief for those who are struggling because of this pandemic, and many are struggling. People need help. They need help to pay their rent or mortgage. Parents need help putting food
Notice
on
how
the table.
ACB's like, who cares?
The millions of American
What does this have to
workers
do with
who
my
have lost
confirmation?
Their jobs need help making it through the end of the month. And small businesses need help so they don't have to close their doors for good.
No, they just need to be open.
But sadly,
Let them
Senate
open.
Republicans have rushed
Let them open
to
and do
hold the
business.
Supreme Court confirmation hearing rather than help those who are suffering through a public health crisis not of their making. As I said yesterday, these priorities are not the American people's priorities. Since President Obama signed the Affordable Care Act into law, Senate Republicans' #1 priority has been to tear it down.
Thank God.
And remember, before the ACA, the Affordable Care Act, insurance companies held virtually unchecked power over our healthcare system. They could refuse to.
Except they couldn't raise their policy prices without approval from you. That was pre-ACA. That was pre-ACA. But an interesting thing happened with the ACA. Once you passed it, you started approving policy increases every single year to the tune of 18 to 25%. Every year, year over year. You didn't used to do that. Only when the ACA passed. Why is that? Did you bargain with the insurance companies? Did you tell them you'd allow them to raise rates? Did you lie to our faces the entire time where you said that rates would be kept low? Did you lie only the entire time to our faces while working behind the scenes with the insurance companies and saying we will approve every single rate hike every single year like you have? All of them.
Cover basic medical expenses like maternity care, like mammograms, like prescription drugs, or hospital stays. Worst of all, if you were sick, they could deny you coverage altogether, and there was nothing you could do about it. Over the last 9 years, Republicans in Congress have tried 70 times to repeal or roll back the ACA
Not
in
enough.
the United States Congress.
Not enough
In
times.
2013, Senate Republicans were so desperate to stop its success that they shut down the entire government for weeks. After President Trump was elected, Washington Republicans spent nearly a year trying to repeal the ACA. But I will always remember the thousands of Americans from all over our country and all walks of life
Big
who
Red
crowded
64
into
says,
the
can
halls
someone tell her
of
to
the
shut the
United
hell up
States
and get to
Capitol
her
to
get her facts
require
right,
that
please?
lawmakers see their faces and understand how they would be hurt if there was a repeal of the Affordable Care Act. Brave activists
That's compelled government
in the
speech.
disability community staged sit-ins on the Hill. Seniors protested to keep prescription drugs affordable. Mothers and fathers walked the halls with their children in strollers to show Congress the face of those who depended on the law.
You're
And
reading
doctors
a
and nurses
speech, you
protested
embarrassment.
to protect their patients' access to the care they desperately need. Together with many of my colleagues, I joined civil rights and community leaders to speak to the thousands of people who gathered outside the Capitol as they pleaded, as they begged with lawmakers to do the right thing.
Felipe
All of
Mube
these
says, I thought this was a
dedicated
hearing to hear
Americans demanding that their
ACB,
voices
not a hearing of
be
this
heard.
witch's lies and useless
And they
questions
made a
that she
difference.
knows can't be answered.
They made a difference.
That's
History will
Klobuchar.
remember that late night, thumbs down movement when the great John McCain denied Republicans the opportunity to repeal the Affordable Care Act.
Thanks,
And now,
McCain.
Following a decade of failure,
He
Washington
died for it.
Republicans have realized that the Affordable Care Act is working too well and helping too many people to repeal it without facing serious political consequences. But what are they doing? After suffering the backlash that they provoked by targeting the law in Congress, they decided instead to circumvent voters and try to strike down the Affordable Care Act through the courts. Right now,
Oh,
the
yeah,
Trump
it's just the
administration and
Congress
Senate
that wants to
Republicans
strike it
are urging
down.
the Supreme Court to strike down the entire Affordable Care Act and all of its patient protections. Republicans are scrambling to confirm this nominee as fast as possible because they need one more Trump judge on the bench before November 10th to win and strike down the entire Affordable Care Act. This is not hyperbole. This is not a hypothetical. This is happening. And here's what you have to know. People are scared. People are scared.
They're scared because of
what
you.
will happen if the Affordable Care Act is destroyed in the middle of a pandemic. There are more than 100 million Americans with pre-existing conditions like asthma and diabetes, heart disease, who know that they could be denied coverage, are charged more by insurance companies.
I want to point out that the Republican repeal proposals all included protections for pre-existing conditions. They included almost all of the good stuff out of the Affordable Care Act, the things that people like. They did. Things that I think probably aren't very helpful, in all honesty, like from an economics perspective. They included those things. Look, it doesn't make sense. It doesn't make sense for me to have coverage for my pre-existing conditions on the same pay scale that someone who's healthy has. Because my narcolepsy drugs, because of government intervention in insurance, my narcolepsy drugs, if I exercise the purchase of them on a monthly basis, cost over $1,000 a month. They just do. It shouldn't. There's all sorts of reasons that they shouldn't, but they do. And so, like, why does it make sense that for me as an individual, I should get $1,000 of medical prescription coverage per month for less than $1,000 every month? I'm guaranteed to need it. Technically speaking, why should I get that? Now, I should be able to buy insurance coverage that doesn't cover that drug, right? Like, I should be able to do that. That would be fine. Like, oh, I can buy coverage for anything not relating to that specific drug or that monthly payment, and that would make sense. I should be able to do that. We could do that. But Republican proposals went farther than even I would. And they said, no, we're going to include pre-existing condition coverage. We're going to include that. Gay and Still at Large says, chat, please call your mom tomorrow. Because ACB is proof the only way you can learn to keep your cool by listening to people this stupid is to be a mother of 7 children. All right, here we go.
If Donald Trump is successful in getting rid of the Affordable Care Act, and because of the coronavirus, more than 7 million people have now a pre-existing condition that they didn't have earlier this year. Those who depend on the ACA are afraid of their lives being turned upside down if the court strikes it down. They know what could happen. And Judge Barrett, I will share with you and the American people a list. No protections for pre-existing conditions. Higher costs for health care for women.
Nope.
And people over the age of 50. Young adults kicked off their parents' insurance. More expensive prescription drugs.
Young adults should be kicked off their parents' insurance.
For seniors. Insurance companies refusing to cover mental health care. Insurance companies refusing to cover maternity care.
When did that happen?
Mammograms, cancer screenings, or birth control. Insurance companies reinstating annual and lifetime caps. And more than 20 million Americans losing insurance at the worst possible time, again, in the midst of a pandemic, including nearly 2 million Texans, 607,000 North Carolinians, 288,000 South Carolinians, 227,000 Iowans, and 4.2 million Californians. And the pain of losing these protections would disproportionately be felt among the 9 million African American, Latino, Asian, and Native Americans who gained coverage under the Affordable Care Act. But this isn't about statistics. This is about millions of real people living real lives who deserve their government and its institutions to see them and to heed their call. And I know a Republican member of this committee said earlier today that the people who will lose health care are somehow not relevant to this hearing.
They're not.
I disagree. Helping these people is supposed to be why we are all here, why we all ran for office in the first place.
It's not why any of you ran for office, like you liar.
Perez.
Oh, yes, please. Oh, God, the glasses.
Felicia is a writer, a public speaker, and former high school.
I could not have guessed that she's a writer and public speaker. Right, because she writes garbage and sits in a park yelling, and someone might hear her. Oh, come on.
Teacher from Southern California who now teaches at the University of Nevada, Reno. She has multiple pre-existing conditions, including arthritis, asthma, and a rare autoimmune disorder that caused tumors that have wrapped around her optic nerve and part of her brain. Her life depends on periodic cancer-fighting infusions that cost $160,000 a year. Felicia is terrified. She knows that without the Affordable Care Act, she could not afford ongoing treatment, the treatment she needs to stay alive.
Just give
And here's
Medicaid to
exactly
these
what she
people.
said, and I will quote. My life is in the hands of people I do not know, who do not know me, who are essentially telling me I don't matter, that my life doesn't matter, that my health doesn't matter, that the day-to-day quality of my life doesn't matter. And that's really hard.
That's how it is, no matter whether you have insurance or not, whether the Affordable Care Act exists or not. If you are sick, in need of care, that is always true.
Tragically, Felicia's story is not unique. Her fears are shared by millions of Americans. The Affordable Care Act and its protections hinge on this Supreme Court and the outcome of this hearing. Before being elected,
Keep reading your speech,
President
you
Trump promised
cretin.
that every justice he put forward would, quote, will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare, unquote. Judge Barrett, 18 months later, you criticized the Chief Justice for upholding the Affordable Care Act when you concluded, quote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. My question is, how many months after...
That's not a criticism, you dumb pile of trash. That is true. Roberts would agree. He said he was doing it. He said this isn't the argument the government made. It's not the argument that Congress made when they passed it. But we're going to do it to save the statute. It's not a criticism. It's just reality.
After you published that article, did President Trump nominate you to be a judge on the Court of Appeals?
Senator Harris, I apologize. I don't remember the timing of that article. I was nominated, I believe my nomination to the Court of Appeals was announced in May of 2017.
That's correct.
But I don't remember when the article came out.
The article was published in January of 2017, so that would have been 5 months later.
You knew the answer!
Justice Ginsburg, whose seat you are seeking to fill, provided the critical fifth vote in a 5-4 decision that upheld the Affordable Care Act. So let's lay this out for everyone who's watching. As I've discussed previously, 1, Republicans have spent a decade trying to destroy the Affordable Care Act. 2, Donald Trump promised to name a Supreme Court justice and Supreme Court justices who would tear down the Affordable Care Act. 3, President Trump is before the Supreme Court right now arguing that it be struck in its entirety. 4, the Supreme Court could be just one vote away from overturning the Affordable Care Act and all of its protections, including for everyone who has a pre-existing condition or may ever get a pre-existing condition. In other words, the Affordable Care Act and all its protections hinge on this seat and the outcome of this hearing. And I believe it's very important that the American people understand the issues at stake and what's at play. Judge Barrett, the day after President Trump announced your nomination to the Supreme Court, he tweeted, quote, Obamacare will be replaced with a much better and far cheaper alternative if it is terminated in the Supreme Court.
Good. Please do it.
But in reality, there is no alternative that protects the millions of Americans who depend on the Affordable Care Act every day. The horrifying truth is that President Trump and the Republicans in Congress are fighting to take health care away from the American people in the middle of a pandemic, as I have said. President Trump
but what you said was a lie.
That he wants to protect the American people's health care. But the reality is right now he is asking the Supreme Court to take it away, period. Senator Klobuchar, Judge Barrett, asked you earlier today, but did not receive an answer. Prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? And I'd appreciate a yes or no answer, please.
Well, Senator Harris, I want to be very, very careful. I'm under oath. As I'm sitting here, I don't recall seeing those statements, but let's see, I don't recall seeing or hearing those statements, but I don't really know what context they were in, so I guess I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements.
Well, I imagine you were surrounded by a team of folks that helped prepare you for this nomination hearing.
I have
That was after she received the nomination, you dummy. You just asked her if prior to the nomination she saw the statements. Now you're going to after the nomination when there's a team of people preparing her for it.
Yes.
But let me finish if you don't mind.
Oh, I'm so sorry.
Did they inform you of the president's statements and that this might be a question that was presented to you during the course of this hearing?
When I had my calls with senators, it came up. Many of the Democratic senators wanted to know about the Affordable Care Act and to satisfy themselves that I had not made any pre-commitments to the president about it.
And so you then became aware of the president's statement, is that correct?
Let's see, Senator Harris, in the context of these conversations, I honestly can't remember whether senators framed the questions in the context of President Trump's comments. Perhaps so. I think from my perspective, the most important thing is to say that I have never made a commitment, I've never been asked to make a commitment, and I hope that the committee would trust in my integrity not to even entertain such an idea, and that I wouldn't violate my oath if I were confirmed and heard that case.
So just so I'm clear, and then we can move on, are you saying that you are now, before I said it, aware or not aware that President Trump made these comments about who he would nominate to the United States Supreme Court?
All right, Senator Harris, what I was saying, I thought you initially framed the question as whether I was aware before this nomination process began. And my answer to that question...
I'm now asking you if you are aware, were you aware before this hearing began?
When she got cut off?
So you're changing, you're asking me now whether I was aware before the hearing began?
As a follow-up question, I am, yes.
And what I said was that when I had my calls with Democratic senators, this question came up, and I don't recall, but it may well have been that they referenced those comments in the course of those calls. Even if so, that wasn't something that I heard or saw directly by reading it myself.
Senator Leahy asked you earlier today, but I think it bears repeating. Do you think it is important for the American people to believe that Supreme Court justices are independent and fair and impartial? And that is a yes or no answer, please.
Don't tell me how to answer a question.
A number of my colleagues have asked you today.
I would have given her at least a paragraph of an answer. Don't fucking tell me how to answer a question. Don't. You don't have any reason to tell me how to answer a question. Shut up.
Whether you would recuse yourself from cases on the Affordable Care Act. You did not directly answer their questions, and instead you described a process by which that would work or happen. And so my question is, isn't it true that at the end of that process, regardless of that process, that it would be you who ultimately would make the decision about whether or not you would recuse yourself?
That is true, and I can't have you elicit a commitment from me about how I would make that decision in advance. That would be wrong.
Right, and what I've asked you is that, is it not correct that that is the process, that ultimately it would be you, and you alone, that would make the decision about whether you would be recused? You've already opined on the constitutionality of the Affordable Care Act, and that position satisfied the president's promise to only nominate judges who would tear down the Affordable Care Act. And Senate Republicans rushed this process so that you could rule on this very case. The reasonable question about your impartiality will undoubtedly hang over this court's ultimate decision in the Affordable Care Act case if you refuse to recuse yourself. I strongly believe that. Supreme Court justices
Thanks for not asking a question.
Consider the consequences of their decisions on people's lives. Earlier this year, the Supreme Court ruled against President Trump in his effort to repeal DACA protections for Dreamers. Children, of course, who have arrived in the United States, many before they could talk or walk. Chief Justice Roberts wrote the opinion for a 5-4 majority that included the crucial vote of Justice Ruth Bader Ginsburg. The court rejected the Trump administration's attempt to end protections for Dreamers. Chief Justice Roberts said the administration had not taken into consideration the fact that many Dreamers relied on those protections when they started their careers and businesses, when they served in the military of the United States, when they bought homes, and when they started families. Senator Hirono asked you whether it is
that was
appropriate for a
embarrassing.
Supreme Court justice to consider real-world impacts. But you're a sitting judge now. So my question is, in deciding whether to uphold government action, do you currently consider the consequences of your rulings on people's lives?
No.
Well, Senator Harris, that's part of the decision of every case.
And so you do.
Every case has consequences on people's lives. So of course I do in every case. That's part of the judicial decision-making process.
And would you do that as if you are actually voted on the United States Supreme
No,
Court?
she'll
Would you do that
somehow
as well?
stop the process.
Senator, considering how the resolution of a dispute will affect parties, will affect people, is part of the judicial decision-making process, and I will continue engaging in that process to the best of my ability.
So if the Affordable Care Act is struck down, more than 100 million Americans with pre-existing conditions like heart disease, diabetes, and cancer would pay more for insurance or be denied coverage entirely. More than 20 million Americans could lose their health coverage entirely, including nearly 3 million Black Americans and over 5 million Latino Americans who received access to health insurance because of the Affordable Care Act. Insurers will once again be able to discriminate against that more than 50% of African Americans and nearly 40% of Latinos with pre-existing conditions. Insurers will be able to deny coverage to more than 1/4 of Native Americans with conditions like diabetes, heart disease, and cancer.
Diabetes.
All of this in the midst of a pandemic that is not going away anytime soon. A pandemic
probably by
that,
December.
when age is taken into account, has been 3 times as deadly for Black, Latino, Pacific Islander, and Native Americans. A pandemic that has...
I mean, maybe this is politically incorrect, but it's more deadly towards obese and diabetics, right? Obese people and diabetics. Is that maybe why Black, Native, and Pacific Islanders have a higher risk factor for it? Is the obesity problem maybe a reason? Maybe?
Has killed approximately 1 in 1,000 Black Americans, 1 in 1,200 Native Americans, and 1 in 1,500 Latino Americans. Judge Barrett, would you consider the 135 million people who gained protections under the Affordable Care Act when deciding a case that challenges that law?
Senator Harris, if I were to be confirmed and conclude that I was able to sit on the case pursuant to the recusal statute, and then if I heard the case and decided the case, I would consider all the protections that Congress put in place. And as I said earlier during this hearing, the question would be figuring out whether Congress, assuming that the mandate is unconstitutional now, whether that, consistent with your intent, this is Congress's law, would permit this act to stand, or whether the flawed portion of it could just be excised out. And that is a question not of what judges want. It's not a question of the Supreme Court. It's a question of what Congress wanted in the statute. And that is the statute, that you enacted and extended this health care coverage to millions of Americans.
What weight would you give?
The one where, by the way, they made a deal. The individual mandate was a deal, and it was a do or die deal with the insurance companies. The insurance companies were not on board with Obamacare. They weren't on board with the Affordable Care Act until the rep for the insurance companies stood up and said, if you can make every single person required to buy our product, then we're in. And they did. And they did. The individual mandate was a critical part of the bill, not only for Congress, but for the insurance companies. The insurance companies wanted a guaranteed customer base of every single American. Every single one. And that's how the Democrats wrote it.
The fact that 135 million Americans with pre-existing conditions are now depending on the protections of the Affordable Care Act. What weight would you give that?
Well, Senator Harris, as I mentioned to Senator Hirono, stare decisis takes reliance interests into account because, as I've said before, stare decisis is about keeping stability in the law. So the law often takes into account reliance interests. I can't really say, sitting here, how they would play in or weigh in this case because that's part of the legal calculus of the case. So I can't really give you the kind of commitment or pre-commitment that you're asking from me of how I would weigh factors or how I would structure my decision-making process.
I would ask you to consider, if you are confirmed on the court, a credible benefit of the Affordable Care Act, and that a destruction of its protections will have a devastating impact on millions, hundreds of millions of Americans. Judge Barrett, you testified yesterday that Justice Ruth Bader Ginsburg opened the door for many women in law. And I certainly believe and know that to be true as a personal matter. She was a trailblazer for women's equality and gender equity. As a law student, as a teacher, as a civil rights lawyer, and as a second woman ever to sit on the United States Supreme Court, Justice Ginsburg broke many barriers for women across the country. I believe, all fondly remember her as a person who had patience. She had the will and the vision to make our country a more equal place and a more just place. And one of the things she fought for was a woman's right to control her own body and to make decisions about her own body and health care and reproductive choices. The Constitution of the United States protects a woman's right to choose whether or when to become a parent. And it protects a woman's right to choose abortion. Women of color, immigrant women, women with low incomes, and women in rural areas face significant barriers when attempting to access birth control, cancer screenings, and comprehensive reproductive health care. Moreover, anti-choice activists and politicians have been working for decades to pass laws and file lawsuits designed to overturn Roe and the precedents that followed.
Oh my God.
The threat to choice is real.
Ask a
Last
question.
year, the court heard a case that gave it an opportunity to revisit and overturn its abortion precedent. In a case called June Medical Services, the Supreme Court struck down a medically unnecessary restriction that would have closed all but one abortion clinic in Louisiana. Chief Justice Roberts agreed with the court's 4 liberal members that the court was bound by its own precedent to strike down the Louisiana law because it was virtually identical to a Texas law that the court ruled unconstitutional in 2016. As a result, women in the state were able to receive the full range of reproductive care. But Chief Justice Roberts wrote his own separate opinion in the case to make clear that in the future he could not be counted on to uphold a woman's right to choose. Justice Ginsburg provided the critical 5th vote to strike down the unconstitutional abortion restriction in June Medical Services. So we must be honest about the impact of her passing and the impact it will have on the court's decisions in cases regarding women's access to reproductive health care. Now, my Republican colleagues have said that there is a minimal chance that the Supreme Court will overturn Roe. But back in January, 39 Republican senators, including 10 members of this very committee, signed their names to a Supreme Court brief that asked the court to, quote, take up the issue of whether Roe should be reconsidered and, if appropriate, overruled. So let's not make any mistake about it. Allowing President Trump to determine who fills the seat of Ruth Bader Ginsburg, a champion for women's rights and a critical vote in so many decisions that have sustained the right to choose, poses a threat to safe and legal abortion in our country. After all, President Trump said that overturning Roe v. Wade will, quote,
Guys, this is terrible.
automatically, in my opinion, because I am putting pro-life justices on the court. Judge Barrett, several times today, you have quoted Justice Ginsburg's testimony about not making predictions in future cases. However, she was far more forthcoming at her confirmation hearing about the essential rights of women. In 1993, Justice Ginsburg's confirmation hearing shows that she testified that, quote, the decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It is a decision she must make for herself. When government controls that decision, for her, she is being treated as less than a fully adult human, responsible for her own choices. Then Judge Ginsburg went on to say, quote, it is essential to women's equality with
Oh my
man
God.
that she be the decision maker, that her choice be controlling.
3 minutes.
If you impose restraints that impede her choice, you are disadvantaging her because of her sex, unquote. Now, Justice
Ask a
Ginsburg
question!
did not tell the committee how she would vote in any particular case, but she did freely discuss how she viewed a woman's right to choose. But Judge Barrett, your record clearly shows you hold a different view. In 2006, you signed your name to an advertisement published in the South Bend Tribune. It described Roe v. Wade as, quote, an exercise of raw judicial power, and called for putting, quote, an end to the barbaric legacy of Roe v. Wade. You signed a similar ad in 2013 that described Roe as...
She didn't actually sign an ad. She signed a letter, and an ad was placed next to the letter that contained this was covered in some of the other hearings, that contained verbiage that was not in the letter. The ad is not what ACB signed. She didn't do that. The place took the signatures for the letter and then put an ad with its own literature in the ad. She's covered this so many times, but these people wrote their speeches in advance and cannot adapt them because they are incapable of anything.
Quote, infamous, and expressed opposition to abortion. Also in 2013, you wrote an article about Supreme Court precedent in which you excluded Roe from a list of well-settled cases that you said, quote, no justice would overrule even if she disagrees, suggesting, of course, that you believe Roe is susceptible to being overturned. On the 40th anniversary of Roe, you delivered a speech in which you said that the court's recognition of the right to choose was, quote, created through judicial fiat, rather than grounded in the Constitution. And during your tenure on the Seventh Circuit Court of Appeals, you have been willing to reconsider abortion restrictions that other Republican-appointed judges found unconstitutional. As the Senate considers filling the seat of Justice Ruth Bader Ginsburg,
It's not the seat
who
of
was
Ginsburg.
straightforward enough in her confirmation hearing to say that the right to choose is, quote, essential to woman's equality, unquote. I would suggest that we not pretend that we don't know how this nominee views a woman's right to choose and make her own health care
Up.
decisions. Mr. Chairman, I ask unanimous consent that the following 3 documents be entered into the record. A letter opposing Judge Barrett's nomination from the NAACP, a statement opposing Judge Barrett's nomination from the Planned Parenthood Federation of America and Planned Parenthood Action Fund.
Well, that's 3 people so far that I don't trust.
and a report opposing Judge Barrett's nomination from the NAACP Legal Defense and Educational Fund.
Without objection.
Thank you, Mr. Chairman.
Thank you. Thank you very much, Senator Harris. Senator.
Oh my God, that was unbearable. Sorry, I didn't see Harris's before, so I didn't realize that it was literally just a speech. And she barely asked ACB any questions. It was just grandstanding. Here's the reality. Republicans have already scheduled a vote on ACB on Thursday. So all of this is pro forma. You can imagine that we will have a Supreme Court justice voted in on Thursday. That's almost guaranteed to happen. It's possible that there will be some Republican holdouts that will want more time, but I think the likely outcome is they're just going to vote it in. They don't care. They're just going to ramrod it in. God, that was terrible. Kamala Harris is terrible. Ugh. Okay. Chris French says, listening to this BITCH is giving me a headache. Sinac 8 says, I hope Harris joins the gun violence statistics on the 32,000 side. Oh, whoa. Mithrin Emrys says, 1, Kamala, grandstand all you want. Should be confirmed along party lines. 2, why has insulin skyrocketed under the ACA? Very good question. Where did those affordable, reasonable prices go, Kamala? Perhaps with your integrity absent. Yeah. Yep. There's not much more that needs to be said on that. So, with that said, that is that's the video content I have for you. That's the video content I have for you today. And I think, we'll go ahead and we will do super chats, and then we will be done with that. Done with the show after that. Does that sound good to you guys? I hope so. I hope that's acceptable for y'all. But that's the plan. After we're done here, I'm going to go over to Twitch, and we're going to watch The Class of 1984. Class of 1984 is the movie on Twitch tonight, so I do encourage you to come join for that. But before that, of course, we will read all the super chats that are here. And tomorrow, I believe Drexel will be on. I'm not entirely sure what we'll be doing or discussing, but I believe he will be on for the next 3 days. I don't know. Do you guys like this stuff? I know it's infuriating, but I think it's interesting to watch through these confirmation hearings a little bit. I don't know. Do you guys like it? If you like it, please let me know. If you want to see me do content like this, where we watch hearings, we watch, I want to get some court hearings and stuff like that. But if you want to see more of this type of content, please put it in the comments that you like this stuff. Click like on the video, all of that. I do look at that stuff to try and determine what kind of content to bring you. So if you guys like this, I will keep doing it. Of course, the debates, this next debate has allegedly been canceled. It was supposed to be on Thursday. So we'll probably not have a debate stream with Ty that we would normally have. I'm hoping the third debate happens. There are 2 town halls that are going to happen, one for Biden, one for Trump. I may try and cover those. I don't know if we'll cover them with Ty or not. We'll have to see. I don't know if they'll be at the same time and how we can work it in. Maybe we'll do them recorded like this. I'm not sure. But I do kind of want to provide you guys with some of the ongoing election coverage with my occasional commentary. And again, with Ty, I know our volume was way too loud during the VP debate, and it's mainly because the volume on the YouTube streams are so low. I have them maxed out. I have my computer volume maxed out, and I have the stream maxed out. It's just their audio feeds are so quiet, or mine so loud that that balancing them is really difficult because I can't hear it. But I think today we toned down my volume enough to make it audible for them. And on the next stream with Ty, I have found a way to tone his volume down specifically while leaving the YouTube stream up. So we'll get that fixed on the next joint stream that we do, or we're watching something live, because I really do want to have you guys able to hear it, but it's hard for us because we can't hear the difference in volumes that comes through to you guys. There's just no way to do that. So working on it. Yeah, I do have better equipment than them. I have better mics, better sound baffling. You guys see my beautiful foam? Really tremendous. We hung some foam over here. I gotta get some more foam over there. I've got all the foam panels in the world. I just need to get them hung up. But yeah. Hey, what's up, Camelot? Welcome to the show, man. Welcome to the show. All right, we're on super chat time here, so we will do that, and then we will wrap up, and then again come over on Twitch. We're gonna watch Class of 1984, and then maybe we will do. At some point, I think we have to do nude nuns with big guns, right? Like that has to happen at some point. I don't know if that's going to be tonight, but that's got to happen soon. Okay, let's do these super chats. Malik Foxon, the beautiful foam that's not lined up. It doesn't line up very well. They're different lengths than widths, so it doesn't matter to me at all. It's just how it's gonna go. Okay, Malik Foxon says, who says you don't have to teach about the history of slavery? Effers were knocking down historical monuments of plantation owners, changing the names of buildings named after slave owners because they don't want discussion of it at all. Those idiots. Yeah. There are no serious people that were like, you know what, let's not teach slavery, and certainly not on the right. That's leftist talk. They don't want to talk about the reality of American history, and I don't know why. Bad Dragonite says, for Nick in chat, I'm a firm believer that the best barbecue needs no sauce. Yes, Texan, nailed it. That said, what does the best sauce taste like to you? Sweet, salty, savory, smoky, tangy, spicy, or some combination. Smoky and spicy for me. I want to make a good new recipe for selling it at a takeout place. For me, it's smoky and spicy. That's what I want. And I want some kick. I want heat coming at me on those. So that's my opinion on that. LaPierre Hammer for Prison says, we have distinction between violent and non-violent felonies. What about 2019's US v. Davis, where Gorsuch and Dem said 5-4, those were too ambiguous to be constitutional? I'm not familiar with the opinion in US v. Davis that you're talking about, but if those being too ambiguous to be constitutional, that's fine. That doesn't mean that any list will be too ambiguous. It just means that the existing list is. And they can test that, and they can work on it on a case-by-case basis. I have no problem making the courts try. Like, they're already doing a case. They're already determining whether or not someone's guilty of a felony. They can determine whether or not that felony is violent or whether that person is a danger. They can do that. There already is a case, and there already is a court. It's just one more question that they have to resolve in the matter of the case. Miller video when more must be taught about Reagan's show trial. Hopefully soon. Excuse me. Now that I know that uncivil law is a Second Amendment nerd, it would be great to have him and Kendra Paris on to talk about Miller. Malik Foxon says, so I hate hearing about black voter suppression. I remember reading this article from, I think, Pew Research that pointed out that black vote rose every effing election until Obama's second term. It doesn't seem like black voter suppression to me. You got to realize that when a congressman or a senator says voter suppression, what they mean is regulation on votes. Not necessarily suppression, but stuff like voter ID. Voter ID is suppression. Wait, how is that suppressing? regulating polling places. Well, it's suppressing people. It doesn't suppress anybody. Felipe Move, thanks for the mask. Jeff the Gamer says, shout out to Twisted Puppet. I know you are not watching tonight's stream. May your cat rest in peace and the pain you feel fade away in time. Always remember the good times you had with the cat. Cherish those memories forever. Shots and F's in chat. Oh, man, I didn't know Twisted Puppet's cat died. That sucks. F. Siren Jag says, would whoever dragged out this Senator Cumblo Charles, Klobuchar, let her get back under the bridge? Those 3 billy goats, Gruff, are going to be hopping by any second, and she's hungry. Namru says, thanks, Nick, for going over this. Prayers for your family and their well-being. Hey, thank you. Thank you. We're all doing very well right now, so thank you very much. Democratic Senator says, ACB, let me ask you an inappropriate question and ask you to rule on a case you have nothing to do with so I can get my CNN soundbite and blame the bad orange man. Now let me ask again in 40 different ways because Russia probably, I don't know, reclaiming my time. Ice Wallow Come, thank you for donating. Malik Foxen says, they're practically begging Amy not to rule out the ACA. I'm convinced this is a poorly veiled attempt to try to get her to make a statement saying she won't do it, and she isn't biting because she isn't a puppet and refuses to be. You can see it in her eyes. Namru said, Namru says she asks 2 questions in 31 minutes. God, does she love to hear herself speak? Well, that we saw the problem there, right? Kamala Harris was mansplaining to ACB about all sorts of stuff. Silky Johnson says, Nick, I know the torture of Kamala's voice. It makes your foreskin fall off. Why do they use that argument about women's autonomy and right to choose? Is there a reason for it, or is it just an excuse to kill babies? And do they consider the life of the baby? They don't consider the life of the baby. They don't. That's been the key. That was actually one of the arguments in Roe, although it was framed differently than I would have framed it. They framed it as the state has an interest in the life of the baby, and that state interest weighs up against the mother's interest in her own personal autonomy. And in Roe versus Wade, they determined that in the 3rd trimester, that the balance shifts from the mother's interest in her autonomy to the state's interest in protecting the life of the baby. I would suggest the proper interest balancing test would be in the baby's right to life versus the mother's right in autonomy, not the state. I don't think that, I get that the state is a future tax interest, but I believe that the baby's rights start prior to conception, or not prior to birth, not prior to conception, obviously. And I'll shore that up with a maxim from probate and estate law. In estate law, a potential life is considered a life having real property interests. An unborn baby in estate planning and trust law has property rights in existing property, even though it is not born. We don't apply that to abortion for some reason. We don't see it as a life that exists when we're talking about abortion rights, but we do in probate and trust. All right. Mexican Man and Cheese says she did really well. The woman has 7 kids. She's used to answering dumb questions for hours. If liberal women quit aborting their children, they might be good on their feet too. Dang. 420 Brodong says, hey, Nick, as a normal blue-collar idiot, I find the law very fascinating. So what are some ways for a normal person to be able to understand reading cases or at least get an understanding of them? Any tips or advice? Thanks a lot, Grifter. Look, you can just start reading them. All the major cases, all the Supreme Court decisions are on, they're on the internet. You could pick up a book about it. You can watch YouTube channels like mine, I guess. Uncivil Law probably does it a little bit more. Check him out. But that's how. It's just doing it over and over and over, reading what they wrote. By the way, a normal blue-collar idiot is smarter than 90% of lawyers. So I get the self-deprecating joke, but normal blue-collar idiots are smarter than the overwhelming majority of learned professionals. All we are is someone who spent too much money on a little bit of education. That's it. That's our get. So don't sell yourself short. I can't fix a car or anything like that. A much more useful skill than me being able to read some case law. Ken Jennings, Kiwi Farm says, committee vote is scheduled for the 22nd, but Schumer has said they won't provide quorum for the committee vote, which requires 2 members of the minority for quorum. I wonder if the chair will spring the vote the day before to prevent this. Would be funny as F. I saw that the vote was scheduled for Thursday, I thought. Maybe I'm wrong. All right, Dragon's Treasure says, I want a refund for the super chat. We don't do refunds here. What are you talking about? Roy Margary. Hey, what's up, Tug? Roy Margary says, Tim Heidecker is absolute trash. Rest in power, LA-based comedian. Yes, Dick's Twitter was nuked today, presumably by Tim Heidecker after he went after Baked Alaska. I don't care about Baked Alaska. I care a little bit about Dick because I think he's funny. Even though some of his Twitter takes are kind of trash, that's okay. Like quality or whatever is not the requirement for having a Twitter account. But Baked Alaska, I don't know about his show. I never watched it, but he shouldn't have been deplatformed because nobody should. Nobody should. But from what I heard about it, probably should have seen it coming, but it shouldn't have happened. And it looks like Tim Heidecker might have had something to do that. So that makes him lame. And even if he didn't actually have something to do with it, he tweeted about it, and he should be punched. Politely in Minecraft. Jester of Fire says, I'm getting married on Halloween. What's your best marriage advice? Work at it every single day. It sounds terrible or whatever. It sounds kitschy. It sounds kitschy. It's true. You have to wake up every day and you have to choose to love the other person, even when they piss you off. And they will. And also, don't ever fall for the, you're not the person I married. Because they won't be the person you married even, a year out. First year's the hardest for most people, many people. Many people, many such cases. First year's really hard. Just soldier on. It's fine. And it's okay to be pissed at the other person. But you wake up and choose to deal with the fact that you're mad at this other person. It's okay. And then eventually, like those things will, you'll go, who cares? Like, so they pissed me off. Who cares? Lots of things piss you off and you still do it. Video games piss me off all the time. I still play them. So, but anyway, yeah, you got to wake up and try every day. If you do that, you're set on a good path. Oh, also, she has to do it too. Two-way street. Blaine Cooper says, I envy Joe Biden. I wish I could forget Mitt Romney too. Ryan Gordon says, Booker is a loser. 200 Watt Studio says, Cory Booker, no kids, ask ACB, 7 kids, 2 black. Are you a white supremacist? Frederick Acker says, I really like the show. It always keeps me company when writing school papers. I hope everything is going great for you because I know it's not for me. Oh, Frederick. No, my life is fine. It's fantastic. Minor setbacks are minor setbacks. I hope your life turns around very quickly. I hope things turn around for you. Keep with it. Keep with it. Kaiser TV says, I think that dimwit from Hawaii wasn't accusing ACB of sexual impropriety. I think it was hitting on her. Ryoji Mata says, Durbin trying to influence the Supreme Court judge. Get off the committee, you corpse. Aurelianus says, I've lived in the U.S. South all my life. Never got told I was racist as much as I have been by slimy D.C. polls. Disgusting rhetoric by chronic liars. Salsa Shark 01 says, I'd answer, are you effing kidding me to all of these? Stefan Maurer says, listening to do and sounds like he prefers a Minority Report society where you can be imprisoned for things you might do in the future. That is a scary proposition. It is. It is. Snorum 11 Aru says, streams like this are why nobody goes to the MSM for news anymore. Good job, Mr. Rekieta. Hey, thanks. That's very encouraging and makes me happy. Shy's Place says, hey, Nick, How's the I Stand with Sophie case going? I don't actually know. I've fallen behind on keeping up with it, but it's on my list of things to catch up on ASAP because I know people want an update on it. Malachi Gaming says, did you see Wolf Blitzer put the screws to Pelosi? I did. And then Pelosi accused Wolf of always supporting the Republican position because apparently she's never heard of Wolf Blitzer. Whew. Never mind. Nova Zero says, objection. Who gives a roving schleet? I don't know. Mario Carter 13 says, Republicans smash, Dems pass, Pence loves his wife. Kalinka Pavlova says, A.B. Klobuchar is beyond unlikable, like WTF. She is awful. Awful. Andrew War Snowboard says, Minnesota has been cucked so hard to believe that the Dems are the party of love, compassion, and science. God help us. William Jones says, future program idea. Review of health sharing compared to current insurance. Could be fun. All the ACA flatulence piques my interest. I'll keep that in mind. Twilight Dragon 3 says, is it me or does Klobuchar sound like Nick's impression of Sam Johnson? Kalinka Pavlova says, looks like Klobuchar is trying to stupefy Barrett into a trap. The problem is, if you're trying to lead someone into a trap, you typically have to be smarter than them, at least in the moment. And I don't think Klobuchar has any chance of being anywhere near as smart as ACB. Gerard Garvin says, ACB is a JILF. Kalinka Pavlova says her name should be Klobuchar. She's full of BS. Bad Vibes says, yes, these Dems need to take a long walk off a short pier. Each one of these dummies cannot seem to grasp. I cannot comment either way. No, that was sad. Halesburg says, abortion is not a right. I agree with you. I agree with you, and it's very important to note that many, many scholars say simply that the right was created out of thin air in Roe v. Wade. It was created. That's not a mystery. It's not even that controversial to say. They found the right lodged in some combination of the 4th and 9th Amendments. It's not there, though. It's not there at all. It's a right uniquely held by women. There's no equal protection of the right. There is no body autonomy in almost anything that you do. There just is with abortion. That's where you have the maximum body autonomy. You have to be a pregnant woman who wants to kill her baby. Then you get body autonomy. If you're a man, you don't. What body autonomy do you have? Like, in all honesty, your drugs are regulated. Your doctor visits are regulated. Your tattoos are regulated. Your piercings are regulated. What body autonomy do you have? Abortion? Barely regulated at all. I'm pretty sure there are more regulations on tattoos than abortion. In fact, you can't get a tattoo under the age of 18 in, I think, any state in the country. You can get an abortion at 14. And in many states, they're prohibited from telling your parents about it. Think about how crazy that is. Body autonomy only exists if you're a pregnant woman who wants to kill her baby. Horatius763 says Brown versus Bowe should be overturned. Unconstitutional. Andrew War Snowboard says the party of Planned Parenthood wants you to think they care about infant mortality. They're the worst people on earth. Angry Baneling, how does one get pregnant at 14 anyway? You respond to a DM that says open Bob show vagine. Once you respond to that, you're pregnant. Horatius says she is a representative of Silicon Valley and shill, talking about Kamala Harris. Mario Carter says Camel Toe was busy speaking to an empty parking lot. Amateur Ant says McCain was an evil warmonger. Gunnar Renee Oy says, without congressional staffers, half the Senate would get lost in the corridors and forget to show up to meetings. Not even a joke, which might be an improvement. That should happen. Corono, dang it, rip me, gay now. Amateur Ant says, headboard Harris looks like she just got done with a bunch of 80-year-olds. Horatius763 says, personalized individual appeals to emotion at Simpin. Mario Valenzuela II says, California forces you to get health insurance. That person Kamala mentioned would not lose it. Kyle Robertson says, where are the GD questions? Good question. Good question. Seedfan85 says, I've seen studies linking COVID and Neanderthal DNA. Kalinka Pavlova says, Harris probably doesn't know what a Pacific Islander looks like. And yes, my people are fat, but not dying from COVID in large numbers here, as far as I know. Kalinka, I was just talking to Lady Raggets about how much we want to go back to Tahiti. I know you're not there, but I just wanted to let you know. Mario Carter 13 says, RBG, I thought she owed her career to Willie Brown. Rogue says, Kamala Harris, when she talks, get on with it. Eclipse Warlord says, the Affordable Care Act caused my insurance costs and copays to increase around the board. Being diabetic for 30 years sucks enough without that BS. I agree. Insulin has just gone under the ACA. I hope Trump is right about reducing the price of insulin. He talked about it at the debate. I really hope he can lock that down. I know lots of type 1 and type 2 diabetics who could really use it. Lancelot 652 says, get on with it, Kamala. Do you plan on boring everyone to death with so much talking if you get elected? Yes. She'll probably be the most active vice president we've seen in a while. Kalinka Pavlova says, Camel A, proving Dem narcissism like girl, ask your question. Gawker's death rattle says, I didn't really know what the word interminable meant until enduring the endless drone of Harris. Holy tap dancing Christ, what an auditory gauntlet. Tony Neves says, Nick, can you cut your ACA rantings from the stream into a video so I can use it as a source in the future? I'll see what I can do. I've been holding off on doing clips lately, not because I'm canceling them, but because I'm retooling how the process works. And I need to talk to my clip guy about it, but I'll think about it. I'll see if that's something that could be worked up. Samantha Schoner says, I can't wait for Thursday. I bet I'll be able to hear the reeing all the way here in Japan. Rovonex666 says, no wonder everyone sticks their pipe in Kamala's mouth. They're trying to shut her up. Oh my gosh. Fast Game Master says, Andrew Yang would have been a better choice for VP than Kamala, but Yang deserves someone better than Joe, in my opinion. Gunnar Renee Oy says, they tore down statues of Hans Christian Heg, Frederick Douglass, and Abraham Lincoln. Weird way to protest against slavery by tearing down the statues of people who fought against it. Seed Fan 85 says, can ambiguous decisions become super precedent? Super precedent, like there isn't a thing, like super precedent isn't a thing in the law. It's just a classification scholars give to say that, look, no one says that these things should be overturned. She says Marbury versus Madison. Apparently she's not aware of my opposition to Marbury versus Madison, but that's okay. You've got landmark cases. International Shoe, for example, is a Supreme Court case. It determines, it's one of the big jurisdiction cases, and nobody thinks that that's the wrong test. They all think International Shoe is fine. This is not a case that's being challenged. It's a case that's cited in almost every federal court that involves diversity jurisdiction. It's a super precedent by any objective standard, but the court doesn't call it that. It's just a precedent. So, there isn't like a way to become super precedent in any official way. Death Trout says, why does Harris always sound like she's on the verge of crying? I'll say the same thing I said about Klobuchar, because she looked in the mirror that morning. Derpy Jew says, Fall Guys when? I don't know. I need to probably get it. Kulfi 2A wannabe Hunan Muhammad says, so for a barbecue sauce, you want it to be Lagavulin 16? Yes. Not even joking. I should probably just put a bunch of, like a whole bottle of Lagavulin 16 in a pot and reduce it to a quarter of what it is and make a syrupy sauce out of that. That umbrella guy says, refund this super chat, Grifter. Look, Grifter can never refund a super chat ever, and I will not. Robert Stratton says, Senator Kennedy at the end today brought shame to the abusers. It's worth a watch. I'll give it a look-see, and maybe we'll work out a show where we go through some of the other ones. And that's it. That's what we have for today, guys. Thank you so much for watching. I really appreciate it. Thank you for being encouraging about the nature of this type of video. I will look for more opportunities to do stuff like this if you guys like it. There will be one more short video posted on this channel in the near future, and that will just be an updated type, like new viewer video that'll go up there, but it'll basically talk about how this is a live show. This will be a live show. It's going to stay a live show. And remember that the short content is going to be ramped up very soon, and that's going to be on the Rekieta Media channel. They will be two separate beasts. All your live content will be here. It will be a talk show. That's what it's going to be. Everything else will be on the Rekieta Media channel. Specifically, that short content, both legal and non-legal topics, will be over there. All right, guys. Thanks for the help in figuring all this out. Thank you for continuing to subscribe and support the show. I really appreciate it. Outro's coming like Omar. We'll see you over on Twitch. Peace. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some law-splaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an ardbeg, a bow, more a love rug. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, the guests are all planet folks, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed. So pour out a glass for the tea post on Twitter as we hear law-splaining tonight. From the white shores of Nan to the hills of Glenlivet,